May I seek
You are not mentioning date.
extremely urgent one?
What is the urgency?
It is appearing as item 79, and it was moved before your lordship when the state administrative tribunal was not functioning. And we challenged the railway health department recruitment process, where the rule of game has been changed when the game has already started. That was the principle settled by this court. My lordship declined to initially accept the petition, but that tribunal, you have to touch tribunal, whatever your lordship give. That went up to division bench, and your lordship, the division bench held that it is entertainable. In the process, my lord, the selection process continued. My lord, ultimately, your lordship's court, it was remanded, my lord, with a direction that it should be heard by the single bench. And your lordship was pleased to accept the same. My lordship has already passed a verdict, my lord, on this. That yes, writ is maintainable. Not in my matter, in another matter, my lord.
What is the urgency?
Urgency is, my lord, the selection is already over, the panel is already made, my lord, appointment will be given.
Well, Lord, it is appearing, I will not update it. Sorry.
Otherwise, my lord, it will become infructuous if the appointment is given.
Sorry, I have not updated. It's not yes, in service determination, all matters are urgent. If this is urgent.
I am not in service. I could not.
Maybe, but I have heard it. I have passed an order. Division bench has said, and I have also held in one matter it is maintainable. But that does not mean that since in spite of the fact that matter is appearing in the supplementary list, it has to be further upgraded. Sorry.
No, it was not upgraded at all.
Lordship no, it is already in the supplementary list.
The day your lordship heard the matter, that day your lordship had an opinion that it is all maintainable.
I understand. I understand. You did not repeat, Mr. Whatever. I will not update further. It is appearing in the sub-daily list. It will be taken up.
Only one indulgence I am praying. Milord, an extreme urgent matter where my lords passed an order while sitting in court number 15 for engagement of the particular Asha Kurmi, Asha trainer. Now, Milord, the National Health Mission has issued a circular, Milord, thereby circumventing all the particular directions given by lordships, and they will start the process. Milord, kindly grant me a leave.
Process will be started.
Sixth is the last day for receiving application, and lordship directed specifically, lordship will recall that to relax the age, so to appear in the selection. Now, Milord, whenever they are giving the application that is being rejected, on the ground, you have crossed the age bar. This I say, Milord, it's a...
give the number date, it will come as per the date.
Milord, kindly give me a grant a kind leave.
No.
So that I can serve. I will serve upon all respondents.
Serve it, but it will not be, no leave is necessary before this court. Because in this court, as per presentation form, matter comes.
Very well, I will give the presentation because your lordship.
Yes, as per presentation, there is no further upgradation, Mr.
It is very shocking that, Milord, they will not obey any order passed by this court. It's really shocking.
Please call the list.
I'm grateful.
My 79 will I can try my luck before the order.
Very well. Tomorrow to be mentioned.
79.
Yes.
Kindly, take me Alice. Problem.
Item number 1.
Not sure. Item number 1 came up at our instance, the North Barakpur municipality, the only inadvertent typological omission in the appearance. It will be the North Barakpur municipality.
Yes.
North Barakpur municipality. In the appearance. In the order dated January 28th. In the appearance, it's written Barakpur municipality. It should be not Barakpur because in the paragraph 2, it's already mentioned. Just that a small omission, inadvertent omission.
But in the body of the order, it is already written not Barakpur municipality. How does it make any difference?
There, it's not Barakpur because there are two different municipalities.
But in the body, it is already written.
Just as a small thing in the appearance.
This is too much. I thought in the body of the petition there was a requirement of correction.
My apology, it's absolutely correct. Just a small.
That's why if I could understand your purpose of mentioning, I would not have allowed your mention.
This
is too much.
Lordship, just allow me this time. This will.
In the body, it is specifically written that North Barrackpur municipality.
It's
Then-
mentioned. It's mentioned. That's
Then-
just a small thing.
Show me that which paper was given to my officer
It was
for appearance.
it was a small sheet written in
Yes,
red
because these discrepancies are there.
in a red ink. It was mentioned. Not by we mentioned it. Not by
You may
Barrackpur.
say mention, but you have to satisfy this court
If the
that
cheat
what
is- if
paper
the
was
cheat is
given to
there,
my
I
officer,
can
Mr. Shubhendu Mukherjee. Ne? Yes, Shubhendu Mukherjee.
If the cheat is there, I can show. Yes, I personally run. Whatever it may be, I'm not just a small indulgence, Lordship. Just a small indulgence.
Make an application. Make a can application. I'll correct it.
Lordship.
File an application. Serve notice upon other side. Serve
No, we have
copy of the
served.
application and then mention matter will be included in the list under the heading application. It will be taken up.
Lordship, please.
Yes, yes. File an application for correction.
No, it's a
Disposed of matter. So
disposal.
therefore, file an application.
Lordship, for just a
No.
small omission.
You please file an application. Issue. Matter has come up at the instance of the learned advocate representing North Barrackpur Municipal. You are representing North Barrackpur
North Barrackpur.
Municipality. Being respondent number 6 and 7. The matter has come up in the list. At the instance of learned advocate representing North Barrackpur Municipality, being respondent number 6 and 7. Seeking correction of the order dated 28 January 2026. Stop. Next paragraph. In the cause title of the order dated 28 January 2026, inadvertently, instead of North Barrackpur Municipality, Barrackpur Municipality was transcribed. Quote unquote, quote unquote. Stop. Barrackpur Municipality shall be read as North Barrackpur Municipality. Next paragraph. Department is directed to incorporate necessary correction. Stop. Next paragraph. This order forms part of the order dated 28 January 2026.
Grateful, Lordship. Grateful.
Next matter.
Item number 2.
My lord, I am for the respondent number 1 and 4. I am praying for not this week, my lord. Not this week.
Why?
My lord, the officer is on the way and he will come today to affirm these documents.
Yes.
Affirm the documents, my lord.
But this order was passed on 2nd January. Today we are on 3rd of February.
Yes, Lordship. The officer was not available, and he is coming today. He's on the way to come and affirm the reply. The
Not
previously,
reply. It's a question of filing a report. No reply. And
the
I have
compliance.
given adequate time.
Yes, Lordship.
I have done wrong. I should have given only 7 days time.
My lord, we have sent the
After
draft
giving
long
such a
before,
long
Lordship.
time, matter was taken up on 2nd January and it is fixed today, 3rd of February. If this plea is taken,
My lord,
then
we have-
henceforth in these matters I will give 7 days time.
My lord, we have sent the draft long before. The officer was not
That
available.
I am not concerned.
I beg apology, Lordship. Give us some time because he will come today. He's coming. He's on the way. He will come.
We will wait when he will come. There are no other officers.
The officer
The
has been
department.
changed. Due to this reason, the
Court will
officer-
wait after granting 1 month time to file a report. Generally, in this matter, 7 days, 10 days time is given
Yes, my lord.
for filing a report. for abundant precaution that there should be no difficulties, so far department is concerned, I have granted 1 month
My
time.
lord, we have communicated
Even
the
then,
department for
even
several
after that,
times.
even after that, this plea is taken that further 7 days time or let the matter be adjourned for a
My
week.
lord, give us some time as your lordship's convenience. My lord, we are not seeking for 1 week time.
Because other matters on similar issues are fixed regularly. If this matter is fixed on Monday, it will be added with similar other matters.
My lord, humble request, give us some time. We will file the
Issue.
complaints.
At the time of call, accommodation is paid for on behalf of Union of India to file report in terms of the order dated 2nd January 2026. Stop. Next paragraph. Hearing of this matter stands adjourned till Tuesday next, comma. February 10th, 2026. Item number 3.
For the petitioner, my lord, led by Mr. Firdaus, he is engaged into court.
Led by Mr.
Led by Mr. Firdaus Samim, my lord, he is engaged into courtroom number 18, my lord. For that reason, I am taking for a short pass over, my lord.
My lord, in that case, my lord, kindly make it not today. In that case, my lord, there was a direction and in paragraph 7, my lord.
Just a minute.
My lord.
Report is filed by State Bank.
না রিপোর্ট কোনো ডিরেকশন ছিল আমাদের রিপোর্ট
এর উপরে ডাইরেকশন ছিল ক্যান্সেল দেওয়া whether you have released the pension
That is
in
my
the month of
instruction
May.
from the month.
And current pension is
And
being
current
paid.
current pension, my lord, the PPU was in Guwahati. From that Guwahati, the PPU has come to AG Bengal. But from AG Bengal, it has not gone to the pension cell of the SBI. It is yet to, from AG Bengal, it is yet to be, yet to go to the pension cell. Once it goes, it will be done. The current pensions will be.
And what about this consolidation of pension?
My lord.
Consolidation of pension?
No, area we have paid, already paid, my lord.
No, for attaining 80 years of age.
Yes, that is that was the revision was done, my lord. That has been done, my lord.
Revision has already been done.
But done, my lord. That is my instruction.
And the petitioner is getting pension at the revised rate from the date of attaining age of
my lord.
80 years.
My lord.
So what more is required to be done?
My lord, nothing.
Nothing. So from
Only the petitioner.
From the month of May 2025, petitioner received
Yes.
arrear pension.
Arrear pension.
Then current pension is not being paid.
Not being paid because it is lying. PPO is lying in the AG Bengal. It has not gone to the pension cell of the SBI.
Petitioner was an employee of SBI.
No, my lord.
No. But the pension is disbursed.
Pension is disbursing authority.
So this pension payment order, which was transmitted from Assam to AG Bengal,
my lord,
that will be required to be sent to the to SBI.
SBI
pension cell of SBI.
Yes, CPPC.
Have you served notice upon SBI? Sorry, have you served notice upon SBI? Yes, have you served notice upon SBI? Show me.
Why you people not came with the brief?
Yeah, I mean.
Train your juniors to be ready and because for a one advocate, it is not possible to address all the courts.
I know, Malad, and each and every matter, Malad,
Nothing remains. Everything has been disbursed.
But regarding
hold your breath. Hold your breath. Tell them to read briefs, at least to be made ready. If my previous order could be read,
yes,
then everything will be clear to the junior, to your junior.
Not only that, Malad, when I came from my house, I told them what is the meaning of octogenarian.
So it is lying in the office of the Principal Accountant General, ANG, West Bengal.
Yes, my lord. That is my instance. It has come from Guwahati to AG Bengal.
Yes, my lord. Guwahati to Jadavpur, my lord.
Yes.
The pension, my lord.
That is clear. Now he is submitting.
Where is the PPO?
Representing bank. Who is representing AG Bengal?
I think AG Bengal ki party.
No. Last
it was made party.
It
was served.
party. আমাকে দাও নি কিন্তু অ্যামেন্ডেড টু এটা কস্ট এটা দিলেই হবে আর কিছু দিতে হবে না অ্যামেন্ডেড কস্ট এটা দিলেই হবে না দিয়েছিল কি ভুল তো করবে না মনে হয়
When it was served? Tell me when it was served.
20.
Yes. Take back the original. 30. Find it from there.
30. I have.
30th January.
30 January. 21 is 28th January. The tracking report says item delivered on the bottom line of page number 8. And another is page number 9. Bottom.
Where is the postal slip?
AG Bengal also. আমাদের খবর পেলেন ইনফর্ম
It says item delivered to Kolkata GPO.
No, madam.
Page 8.
Item delivered means item delivered to the destination. According to the madam, definition, FAQ definition of the postal, item delivered means item delivered to the recipient. The bottom portion. Item booked, that is first number, kindly start page number 9. It will give. Item booked, thereafter item bagged, thereafter dispatched, thereafter bagged again, thereafter dispatched, thereafter received, thereafter invoiced, thereafter delivered. So delivered means delivered to the recipient.
In both the cases, the page 9 also, item delivered,
Yes, madam.
30th January, Boshisto ESO.
Yes, madam. One is item.
No.
That is what?
Yes.
That is delivered to the recipient. If I go through that, because of that one, there is an FAQ of Indian postal. So item delivered means item delivered to the recipient.
It is Kolkata GPO DC.
Yes, madam, because that AG Bengal is within that.
And that is on 28th January.
28 and another
28th January. This order was passed on 23rd December. Why after such a long time?
somehow.
Today we are on 3rd of February. Why you have taken so much time? This order was passed on 23rd December.
Because of that one, I might take the instruction with that one, the person ready will come to the my.
After more than a month, you have effected service upon the additional respondent.
Yes, because of that one, the lady came to, because the person came to my chamber along with his wife.
For that, client is required to come to chamber. Then
But
what you are saying?
instruction.
What you are saying? For sending a notice, petitioner is required to come to your chamber.
Material exception.
No, not for material instruction. That is.
Otherwise, matter could have been disposed of today. Who appears on behalf of AG Bengal?
Sandip da করতো Sandip.
Previously, Sandip Bhattacharya used to appear. He is no more in this world. It was very unfortunate. Yes.
Unfortunate.
Tomorrow I see.
জিপি অফিস তো এখানে
Esho. Affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph. In spite of service of notice. Principal Accountant General within bracket A and E. And Accountant General within bracket A and a Principal Accountant within bracket A and E, comma West Bengal. And Accountant General within bracket A and E, close bracket Assam, being respondent numbers 9 and 10 are not represented. Next paragraph, learned advocate for the petitioner is directed to serve notice upon the learned advocate who represents Principal Accountant General within bracket A and E, being respondent number 9, by February 2026. Stop. Next paragraph, list the matter under the same heading for further consideration on 12th February 2026. Serve it by 5th February, not just before a day of hearing of this matter.
Today,
Yes.
Item number 4.
Mr. Saha, you take instruction in the meantime.
Yes.
Whether that pension payment order PPO has been transmitted to the pension cell of the bank.
Yes, madam.
Or
That
not.
I will take.
Yes.
Item number 4.
My lord, earlier occasion, your lordship directed the respondent authority to instruction. My lord, here my candidature has been rejected on initially two grounds, assigning two grounds.
Who is
that-
appearing for the petitioner? Respondent.
Somebody appeared.
He is Joshojit Mukherjee.
I think led by Mr. Partho Ghosh.
Not to inform.
Like
Item number 5.
I also, I think Mr. Mukherjee is appearing.
Partho Ghosh, Joshojit Mukherjee.
But kindly take some tomorrow. I shall intimate both of.
Inform Joshojit Mukherjee. Not today. Item number 6.
My lord, I am appealing for the petition. My lord, on 5th January, your lordship passed an order.
You are being permitted to function as Anganwadi worker.
My lord, that was
And
permission.
remuneration is being paid.
No, no. My lord, I have the.
My instruction, my lord,
This is only.
the immunization has already been paid and also engagement letter also given to him.
My lord,
Well, and
out of
January,
54,000, only 36,000 has been disbursed. on
Something has
7th
been paid.
January. On
Why
7th.
you are saying no?
My lord,
Why you are saying no?
my lord, full amount has not been paid. Only
Yes, what is your instruction?
my instruction, my lord, pursuant to my lord's order, my lord, between that period, I have paid entire amount. And my lord, last my lord, on 7th of January, I have given an engagement letter to him, to her, and also, my lord, January means, my lord, the 50% payment has to be made by the central government. That has not been paid, and 50% government. That has been already automatically paid. This is regular basis. January it goes to February. This is my specification, and also my lordship kindly allow me to file one affidavit so that my lord, some papers has been I have to annex and highlighted before your lordship. That is considered. This is it.
Now,
Lordship,
any further proceeding has been initiated by the
proceeding
authority?
already initiated, no further proceeding initiated, my lord. This is by request that the authority don't face it because matter is pending before your lordship. If your my lord is my lord already passed an order in the earlier petition, let it be continued. If my lord pleases, we continue and file a report, my lord, before your lordship. That is, my lord, my instruction and entire things is yesterday night.
Please come to the paragraph 6 of my order.
My.
Mr. Devrai, please read it, paragraph 6.
Paragraph 5, paragraph. It is true.
Yes, yes.
It is true. Order dated that its court permitted the respondent in case of doubt to initiate appropriate voting for determining correct date of birth of the petitioner. But from the submission made on behalf of the state respondent, it appears till date no final decision has been taken relating to determination of the data. Which is
10-7.
yes. Moreover, prima facie, it appears that order passed on after the writ petition being so setting aside superannuation notice dated so at the certificate issued by the school authority, which is according to Mr. Devai Learned Influencer, Twitter has based on which steps have been taken by the respondent number 7 so therefore it transferred after order was passed by this court. Respondent made an effort to obtain certificate from the concerned school 5th December 2025. However, nothing is shown to demonstrate the respondent said 7 made an endeavor to initiate a proceeding against the petitioner to determine her date of birth relying upon certificate of the same school authority produced by this petitioner at the time of her appointment, as well as Aadhaar card, voter ID, PAN card, more. No final order is filed relating to it. It's the admitted fact, but I am submitting the peaceful manner. Certificate from school authority, certificate from Aadhaar card. I have shown the Aadhaar card. All are, my lord, different. All are different. I every paper with me, my lord. That is why I am asking, my lord, to lordship kindly give me some.
What is a prayer? Yes, but your prayer is already, your grievance is redressed. So far, this writ petition is concerned.
Yes.
So there is no occasion to keep this matter pending because you have been permitted to join, you are working, you are getting remuneration. So therefore, nothing remains. If they want to initiate a fresh proceedings and ultimately if you suffer an or adverse order, then you can take steps in accordance with law. Court will not keep this matter further pending.
My lord, only direction, my lord, if any proceedings they initiate, my lord, they serve notice to me, my lord.
Yes,
Yeah,
court has
because-
already
because,
served.
my lord,
Court has
already served that.
Court has already directed to initiate appropriate proceedings.
that
Proceed
appropriate-
only served. Notice has already been given.
No notice.
Today I have to go. Well, I brought the notice also. Notice speed post is.
So,
Actually,
Mr. Debra, I am disposing of this
Fine,
matter.
fine.
Since petitioner has been
Liberty loss,
permitted to resume duty or permitted to
Practically
function as
infructuous, sir.
Anganwadi worker
Right.
and remuneration is being paid to the petitioner.
Right.
However, if authority wants to initiate an proceeding, appropriate
Deep
steps shall be taken.
And my lord, remuneration, my lord, total
Already paid.
remuneration has not been paid. Only, my lord, partly remuneration
All
has
remuneration
been paid.
paid.
Because he is saying that the part is paid by the state and part is paid
My
by the
lord, that,
sector.
my lord, direction, my lord, one line, my lord.
No question.
My lord,
Lordship kindly see.
54,
That payment.
54,000, my lord, 36,000 has been
Not
paid. My lord, I produce before your lordship the bank
You
statement.
file your affidavit so that the pay.
আপনি affidavit করলে আমি reply দেব।
I have already stated, my lord, I got the papers regarding payment from TR from number. Matter has been released, funds has been released from time to time. The papers,
Issue.
much okay. It is
In
sanctioned
terms of
order.
the order dated 5th January 2026,
Sanction maybe sanction হয়েছিল।
writ petition is taken up for consideration in presence of the learned advocates representing the petitioner and state respondents. Stop. Mr. Pantu Debrai, learned government pleader, additional government pleader, representing Child Development Project Officer Gosava, being respondent 7, on instruction submits that petitioner was whether any engagement, fresh engagement letter has
Yes,
been
yes,
issued.
yes, yes.
Show me.
Yes. 7 January 2026. Bujia Pailam in the bottom portion.
হ্যাঁ কি বলছিলেন? submits that petitioner has been permitted to function, or petitioner is permitted to function as Anganwadi worker. Under Child Development Project Gosawal, and a remuneration is being paid to the petitioner regularly. Stop. Next paragraph. However, Ms. Dhawal, learned advocate representing the petitioner, disputes payment of remuneration, and it is submitted that a full remuneration is not being paid to the petitioner. Stop. Next paragraph. Till petition. Next paragraph. As the petitioner is permitted to resume. Now, as the petitioner is permitted to function as permitted to function as Anganwadi worker, court finds grievance of the petitioner in this writ petition is redressed. However, However, it appears from the respective submissions made by the learned advocates representing the parties that full remuneration is not being paid to the petitioner. Stop. Authorities are directed to take necessary steps,
if any, lordship can,
to release full remuneration to the petitioner till she functions as Anganwadi worker, provided petitioner is not paid full remuneration. Stop. Next paragraph. However, it is again made clear that concerned respondent authorities or it is again made clear that that concerned respondent authority shall be at liberty to take steps for determining age of the petitioner based on determining কি বললাম সেন্টেন্সটা না shall be at liberty to take steps for finding out date of birth of the petitioner based on valid documents on initiating appropriate proceedings. Stop. Next paragraph. Writ petition says disposed of urgent.
much.
Take it back. That is not required. Next.
My lord, I am for the respondent, my lord.
Deep level.
My lord, I am appearing on behalf of.
Item number 7 called on. Wait.
My lord, I am for the respondent authority, my lord. I am praying for not today, my lord.
Item number, bolo.
Item number 7.
My lord, I am appearing on behalf of the petitioner. Today was fixed as per the order dated 5th January 2026.
My lord.
Fixed for filing of the report.
My lord, I am for the respondent, my lord. Since it was to be filed in the form of affidavit, my lord, and there was a 26th January, my lord, we had some special operations in all the border areas, my lord. Affidavit report is completed, my lord.
No, all the border areas affidavits are being shown.
No, my lord, my lord, my DIG has to come down to this Calcutta High Court for signing, my lord.
Yes.
And since it is an affidavit report in the form of affidavit, my lord, everything is complete, my lord. Only today he will be coming down, perhaps today, to sign the report. That is the reason I am praying for not today, my
But
lord.
when order was passed, 5th January 2026.
My lord, 26th January and
26th January came after 20 days of
my lord,
passing this order.
My lord, they were all in the border areas, employed all in the border areas, my lord. Border areas were sealed, my lord. I am praying for not today, my lord. Tomorrow I will be ready, my lord. Since it was in the form of affidavit, I had some problems. Otherwise, I would have shown it today only, my lord.
issue. It's an affirmed affidavit.
Yes, my lord, that is the problem, my lord. No, it's not affirmed, my
Who
lord.
has given this? Who has given this report? Who has filed this report?
It is Deputy Inspector General Communication.
To you. You have submitted this today.
No, ma'am.
My lord, I was instructed that DIG is supposed to come today to affirm it before the court, in this court, my lord.
Why you are submitting it? It is not affirmed.
Just to show it's not.
At the time of call, learned advocate representing Union of India on virtual mode pressed for accommodation to file affidavit in terms of the order dated 5th January 2026. Stop. Hearing of this matter stands adjourned. List the matter under the same heading for further consideration on 11th February 2026.
Much obliged, deeply obliged.
Item number 8.
Affidavit is one last question. Lordship directed to file the report of the aims participated in the armed force recruitments.
So you have filed.
Yes, who is happening for the Union of India?
Lordship, I am appearing for India. Your
What is your name?
Aishwarya Rajeshri, Your Lordship. Sir, একটা copy টা কি affidavit of service? Okay. Last order.
Yes, what is the report of aims?
21st, the exam conducted, the medical board. But the report.
Why 21st? 2nd January order was passed?
No. I have served the court, communicated, I have hand over to you.
Where is the report of aims school learning?
Reports be filed by the
Your Lordship, we have instruction that the report will directly be filed by Ames Kalyani in
Yes,
court,
that
Your
is the
Lordship.
order.
There was a
But
direction.
in other matters, they are filing it through the learned advocate.
Your Lordship, in this matter, we have just spoken to
Kindly see
them.
paragraph 6,
When the petitioner was medically examined,
21st January.
where from you have got the information that the report is to be filed separately?
Your Lordship, my senior has instructed me that they have spoken to him over telephone that it will be filed directly in the court, Your Lordship. Kindly give us.
Paragraph 7, your Lordship directed to file them to file the report. Paragraph 7, kindly.
In other matters, court is getting report regularly from Ames Kollan through learned advocate. In a sealed envelope, a report of Ames are being filed by the learned advocate for the petitioner.
But no seal envelope hand over to the petitioner, my lord. My lord, that is the problem because, my lord, as per paragraph 7, my lord, maybe, my lord, I will take instruction. For petitioner,
So
but-
contact Ames Kolani and both of you.
But that is,
And
my lord, as per paragraph.
inform Ames Kolani that till date no report is filed.
That's it.
Till date no report is filed.
Possibly, my lord, it is paragraph 7, my lord, your lordship directed them to file. That's why, my lord.
Today I am not
diligence-
passing any order. I am just adjourning the matter.
Yes.
Obtain contact Ames Kolani for filing report. Issue. আচ্ছা একটা ইয়ে করে দাও ওটা অর্ডার করে দাও matter is taken up for consideration today when learned advocate representing the petitioner submits that petitioner was medically examined by the medical board of Ames Kolani on 21st January 2026. Stop. Next, however, during course of hearing, report of Ames Kolani is not filed. As a result whereof hearing of this matter needs to be adjourned. Next paragraph. Learned advocates representing the petitioner and Union of India are directed to communicate this order to Ames to the registered Ames Kolani for filing the report before this court on the next date. Stop. List the matter under the same heading for further consideration on February 2026. Immediately communicate and contact Ames Kolani because in other matters regularly they are filing report.
Or affidavit service.
Upore affidavit service filed by the petitioner.
Yes, your lordship will communicate it.
Item number 9.
The state was pleased to adjourn this matter. Administrative.
Yes.
Maybe post.
Yes, now it is decided that when tribunal is not functioning, then the single bench of High Court can entertain the report.
I'm grateful, my lord.
I have
Yes.
decided in one of my judgments.
Yes, my lord.
Therefore, the matter is
Tribunal is functioning. Filing is being made.
no member,
No
no chairman,
purpose of the
nothing.
filing, my lord.
Next, certain date should.
Yes,
My lord, may I rely on page number 20, my lord, which is the first show cause notice?
just a minute.
Report is required, but not myself.
Just a minute. Yes, yes. Place your case.
My lord, the petitioner is an ARTO, Additional Regional Transport Officer, my lord. My lord, he was suspended by a show cause notice. Initially, the show cause notice, which was dated on 27/9/2024, which is annexed in page number 20, my lord, of the writ petition.
Just.
Let me place my case first. No. ডিসপোজ করলে তো ডিসিপ্লিনারি প্রসিডিংস সেটা চেয়েছে না না ওটা করলে শুধু হবে না পুরো কোয়াশ চেয়েছি আমি
But your where is the show cause notice?
My lord, page number 20, my lord. My lord, in the show cause notice, my lord.
7 September. But this was issued by the Regional Transport Authority, Alipurduar.
Alipurduar, my lord.
So you should approach the.
No, my lord, the petitioner is from Uttar Dinajpur.
Maybe, but the show cause notice was issued by the Regional Transport RTO Alipurduar. So you should approach the.
My lord, this is not just the show cause notice that I am challenging, my lord. I am challenging the entire disciplinary proceedings, my lord.
Where your proceeding was conducted?
My lord, it was conducted within this jurisdiction.
Who was the inquiry officer? Where inquiry was conducted?
Kolkata, my lord.
Where inquiry was conducted?
My lord, Kolkata.
Show me the notice, inquiry
Yes,
notice.
my lord. My lord, page number 22. Transport Department, Poribohon Bhavan. The order was passed by this Transport Department from Kolkata. Hence the jurisdiction, my lord.
Now, what is the outcome of these proceedings?
My lord, we are not aware of the outcome.
Been issued.
No, my lord.
Nothing.
But he is still under suspension. My lord, kindly sees one thing, my lord. In the show cause notice, page number 20, my lord, kindly sees the left-hand side corner of the show cause notice when this was
But a
received.
charge sheet was also issued from Poribon Bhavan, R.N. Mukherjee Road.
My lord, I am challenging from the show cause notice
Yes,
itself.
Place your case.
Yes, my lord. My lord, in the left-hand side corner of page number 20, here it is clearly.
First, a show cause notice was issued.
Yes, my lord.
Where is the show cause notice?
Page number 20. My lord, in the show cause notice, my lord kindly sees it was received on 30/9/2024, 30th of September at 1 p.m. My lord, which I have already stated in my pleadings. Page number 20, my lord has. It was received on 30th of September.
27 September is a show cause notice.
It is the date of the show cause notice, but it was handed over to the petitioner on 30th of September. And in the show cause notice, a time for reply of the show cause notice was given within 3 days. And he received the show cause notice on 30th at 1 p.m. And my lord kindly sees page number 22.
So what you are praying in this?
My lord, he had been suspended on 30th itself. He was not given an opportunity of hearing. My lord, it is in page number 22.
22?
Which is dated 30th September 2024. My lord, he was not given an opportunity of hearing. Thereafter, in page number 24,
Charge sheet was issued within time. Yes.
my lord, in
It
page
has
number
page
24,
25.
my lord, page 25 is the charge sheet. And in page 24, the district magistrate Alipurduar has stated that
No, charge sheet has already been issued within time.
charge sheet was issued, but I was not given an opportunity of hearing, my lord, before initiating the departmental proceedings. My lord, thereafter, the district magistrate had stated that he has no reply has been received from the office despite sufficient time being provided. Not where the sufficient time was given, I asked this question to myself, my lord. My lord, he was suspended from that very day itself. You know, the show cause notice was handed over at 1 p.m. At 3 p.m., he received the suspension order.
What is the illegality in it?
My lord, the 3 days time as per the show cause notice was not given.
Suspension order issued without any show cause notice.
My lord, suspension order was issued with a show cause notice, but the
So where is
time
the
for
illegality?
my lord, the time for replying to the show cause notice before the suspension, my lord.
Yes.
That
You
is the
take
illegality.
time to respond to the charge sheet.
Time was I replied to the charge sheet because being a public servant, I responded to the charge sheet. I appeared before the for the department.
Mandatory that the show cause is to be issued prior to suspension.
My lord, they have issued. There is a purpose for issuing a show cause notice. My lord, every show cause notice comes with a right of hearing, my lord.
There is no provision that the show cause has to be issued prior to suspension.
My lord, but they have issued a show cause notice.
Show cause may have been issued, but if proceeding has been initiated within 90 days from the issuance of suspension, there is no illegality.
My lord, but the suspension should have been issued after 3 days, giving time after 3 days from the show cause notice. As per their show cause notice, I'm relying on their show cause notice, my lord. Claro.
Where are the imputation of misconduct? Why you have not annexed it?
My lord, because that would be a matter of fact, and I am challenging the entire departmental proceedings, my lord.
Hesitated to disclose
And
imputation of misconduct.
my lord, if my lord directs,
Why only the first page of show charge sheet?
My lord, I shall.
Imputation of misconduct.
My lord, I
You
shall.
are annexed to the charge sheet.
My lord, I have not gone into the facts of the case because I am
required. What are the charges? Let me see.
I shall put it on supplementary affidavit if my lord may pleases, my lord. My lord, I shall put it.
Challenging suspension order during pendency of the disciplinary proceedings and the allegations which are leveled against you will not be disclosed.
My lord, the disciplinary proceedings order has
not. What sort of writ petition is this?
My lord, I am on a relying on a judgment, my lord, wherein there has
judgment will come later.
My lord,
first allow the court to go through the allegations.
Lord, I shall put it.
Why this has not been done?
My lord, because on the very first show cause notice only there has been illegality, my lord. I am challenging the illegality from the show cause notice.
The charge sheet will not be disclosed.
And I shall disclose. I don't have any hindrance in disclosing the charge sheet, my lord. I did not want to bother the.
I find there is hindrance.
My lord, I shall because the charge sheet is also in my favor only.
In a suspension matter, when charge sheet has been issued, entire charge sheet is not disclosed.
Yes, I shall disclose, my lord. My lord, even the evidence is in my favor, so I don't have any problem in disclosing the entire evidence.
You have not disclosed it.
My lord, it was because I was challenging a show cause notice from the very first. My lord, I was challenging the very first show cause notice. That is the reason I did not.
Where is the present stage of disciplinary proceedings? Don't be much swayed by the show cause notice. Where is the present stage of disciplinary proceeding?
My lord, disciplinary proceedings has been completed in the month of March of 2025, but the order has not been issued, and
so let the order be issued.
My lord, the petition
let the order be issued
and the suspension be lifted, my lord. In the meantime,
why? What for?
My lord, he has been suspended for more than a year, my lord.
Yes. But the proceeding is there. Where is the illegality in keeping this?
My lord, the proceeding should have
petitioner
been
under
completed
suspension?
within a period of 1 year, my lord, as per this judgment, my lord, which I am
If
relying.
proceeding is not initiated,
The proceeding
proceeding
after
is
initiate.
initiated, no.
My lord, after initiation, my
No,
lord. My lord,
certainly
if I
not.
kindly rely on this judgment.
Please see the rules first.
My lord, here it has been specifically stated that the suspension has to be lifted within a period of 6 months, my lord, not more than that. My lord,
Show me that provision.
Yes, my lord.
No. Show me the provision of the rules.
My lord, there is no.
Please show me the provision
My lord,
of these
there is
rules.
no specific provision as to the
Yes.
period of suspension,
When the
my lord.
proceeding is continuing, there is no requirement.
My lord, that is the reason the judgment
Please
has
show me the rules first. Please show me the rules first.
But in the rules, there is no specific time period, my lord. Well, that is the reason the judgment is coming in between, my lord. My lord, that is the reason this judgment, I am relying on this judgment where it has been stated that the disciplinary proceeding has to be concluded within a period of 1 year after it has started. My lord, from the date of date of charge sheet, which is on 11/11 of 2024, the 1 year period ends in 2025, my lord. My lord, if I may rely on paragraph number 33, page 14. It's a
just a minute.
লিখুন না এখন এটা দিতে পারবো page number 14, para 33.
State or private?
Come to paragraph 8.
Paragraph
8 of your judgment.
Yes, my lord.
Read it.
It continued for more than 9 years.
Read it.
Yes,
So
my
that
lord, I
is
have
the
read
fact,
that.
that is the fact situation.
My lord, I am on paragraph
That is
number
the fact
33.
situation based on which this order was passed.
My lord,
Is it akin to the facts in the present case?
My lord, more than 1 year. My lord, petitioner should also suffer the way this petitioner has suffered, my lord. My lord, I am asking this question to myself, my lord. My lord, in paragraph number 33, if I may read out with your lordship's permission. My lord, keeping these factors in mind, we are of the considered opinion that every employer, whether state or private, must make sincere endeavor to conclude the departmental proceedings once initiated against the delinquent employee within a reasonable time by giving priority to such proceedings, and as far as possible, it should be concluded within 6 months as an outer limit. Where it is not possible for the employer to conclude due to certain unavoidable causes arising in the proceedings within the time frame, then efforts should be given to conclude within a reasonably extended period, depending upon the cause and nature of inquiry, but not more than 1 year.
Yes. Yes, what is the present stage of the proceedings? What is the present stage of the proceedings? I'm asking both of you.
My lord, as far as I'm instructed, it has completed in March 2025. But the order has not been passed.
Completed up to what stage?
My lord, the evidence stage and the final argument stage, as per as I am being instructed, my lord. Because there are
From the inquiry report has been supplied.
Yes, my lord. Yes, my lord.
Inquiry
I have
report-
replied also to the
inquiry report.
Yes, my lord.
Thereafter, second show cause notice indicating proposed punishment.
No other show cause notice, my lord.
When you have when the inquiry report was supplied to you?
Inquiry report was Oh, my lord, there was no inquiry report. The first thing that he had received was the charge sheet, my lord, which was on 11th of November 2024. Inquiry completed after the
inquiry
before that.
The charge sheet.
Yes, my lord.
I'm asking you whether the inquiry report is supplied to you.
My lord, during the departmental proceedings, the inquiry report was not supplied to me, my lord. My lord, the charge sheet was done and he was called for the hearing. Then he
After the inquiry report needs to be supplied to you.
No,
Whether
my
it
lord,
has been
it was
supplied?
not supplied.
Where you have stated in that?
I have not stated that, my lord. But I was only on the documents that was provided, my lord. Even the not sub
Fact you do not work. That is the main problem.
I apologize, my lord. I failed to mention that,
If
my lord.
inquiry report is supplied to this is one aspect of the matter. If it is not supplied, then it has to be considered.
Yes, my lord. That is another ground, my lord.
Why you have not indicated this in this?
Lord, I'm
First
absolutely
of all,
sorry. My
you
lord
have not-
kindly gives me that direction to
you have
file a
not,
supplementary affidavit, my lord.
enclosed the full charge sheet. Then whether the inquiry report was supplied to you or not, you have not disclosed it.
I'm extremely sorry, my lord. Kindly gives me that direction. I shall submit my supplementary affidavit and put all the charges and all the evidences before your lordship, my lord. But in the meantime, the suspension be lifted, my lord, because
How can it be?
my lord, because
How
the
can
disciplinary
you have
proceedings
not
has
disclosed
ended.
nothing in the writ petition? Your suspension will be lifted.
My lord, the suspension starts from 30th of September 2024, which is admitted fact, my lord, and it has been more than 1 year. My lord, only on that ground I am asking for, I'm praying for the lifting of suspension, my lord, as an interim measure, my lord.
Yes. What is your instruction?
No instruction has been received as regard to the merit of the case. Only just instruction. He is holding a civil post. Therefore, it is, that has been over.
That
I
chapter
can
is
take
over.
instruction and I shall
Now,
take-
what is the present stage of discipline proceeding?
in this way, no instruction has been written. Instruction has not been.
Whether the inquiry was concluded, if inquiry is
No, I shall
concluded,
take instruction.
whether inquiry report is supplied to the
I
petitioner
can
or
take
not,
instruction.
whether the inquiry report, if it is supplied, whether the petitioner has responded to the inquiry report or not, and if inquiry stage is over, report is supplied, deliberation is made
Present
by the
status.
petitioner, whether second show cause notice indicating proposed punishment is issued by the petitioner or not. Where are those instructions?
Instruction. I shall take instruction as regard to merit of the case. Status of
Who is the appropriate authority?
appropriate authority?
RTO, my lord.
Director.
Director. The Secretary to the Government of West Bengal.
The Secretary.
Page 25, my lord. Charge sheet. In this order, my lord, Secretary to the state.
Issue. Matter is no. In terms of the order dated 8 January 2026, matter is taken up for consideration. Stop. On previous date, court was considering maintainability of this writ petition, as the petitioner is serving under the state of West Bengal. Stop. Whether the writ petition, whether the petitioner is required to approach West Bengal Administrative Tribunal or not was also taken into consideration. Next paragraph. However, issue is no more recently in view of the judgment delivered by this court on 13 January 2026 on a writ petition being WPA 27327 of 2025 within bracket MD Masidul Islam versus the state of West Bengal and others, wherein it was decided that when tribunal is not functioning, single bench of High Court can entertain. Now, when West Bengal Administrative Tribunal is not functioning, or benches under the West Bengal or benches of West Bengal Administrative Tribunal are not available, writ petition before the single before the single bench of High Court is maintained. Next paragraph. In the writ petition, petitioner has questioned show cause notice dated 27th September 2024, suspension order dated 30th September 2024, and disciplinary proceeding initiated against the petitioner based on charge sheet dated 11th November 2024. However, today learned advocates could not apprise the present stage of disciplinary proceeding or present status of the disciplinary proceeding. Stop. Next paragraph. Learned advocate representing state respondents is directed to, or na, a concerned respondent authority is directed to file a report disclosing the present status of the disciplinary proceeding by fortnight from date. Stop. Next paragraph. Leave is granted to the petitioner to file supplementary affidavit disclosing charge sheet and imputation of misconduct. Now, disclosing imputations of misconduct relating to charge sheet dated 11 November 2024 and other documents if supplied along with charge sheet to the petitioner. Stop. Let such supplementary affidavit be filed by 7 days. Stop. List the matter under the same heading on 10th March 2020.
My lord, suspension, my lord.
No, not at this stage.
10th? My lord, another month will go, my lord. My lord, kindly, my lord. My lord, kindly considers.
Please call the next matter. Item number 10.
My lord, I am for the state response.
My lord, in so far as item number 10 is concerned, I appear on behalf of the petitioner. My lord, I beg to appear virtually. My lord, I am very sorry. My lord. There were directions upon us to serve the writ petition. My lord, we have initiated service. My lord, only in so far as respondent number 3 is concerned, it has come back as refused. My lord, the affidavit of service has been filed with your lordship's officer. My lord.
So service is not complete.
My lord, the respondent number 3 has refused service. My lord, we tried to do it by hand, they refused. We also sent by registered post with AD, that has also been refused. My lord.
My lord, our difficulty is that we have engaged by the LR department, and only an letter of engagement has to come without any writ petition.
My lord, we can serve upon my learned friend, my lord, if he takes the responsibility that he is appearing on behalf of the other respondents.
No, you could have served by postal by post.
My lord, we have served by post, which has been received by all the respondents.
Yes.
As far as respondent number 3 is concerned, my lord, he has refused the service.
What is the matter about?
My lord, the matter relates to, my lord, the petitioner was employed as a contractual worker with the respondent number. Just give me a sorry, madam. Just the petitioner was employed as a contractual employee with respondent number 4, my lord, under WBCACD. The petitioner was employed under Group D. Now,
Under which authority petitioner is was employed by which authority?
My lord, under the West Bengal Comprehensive Area Development Corporation. Respondent number 4, my lord.
Yes.
So the petitioner, my lord, was employed as a contractual worker under Group D, my lord. The petitioner's employment was confirmed by a notification, my lord.
Yes.
Dated 12th of August 2013, where the petitioner, my lord, is if your lordship kindly comes to page 37, my lord, the petitioner is in serial number 121. So the date of engagement is from April 2007, my lord, and the petitioner was regularized by this particular notification, my lord, which was dated 12th of August 2013. Now, thereafter, my lord, there were various notifications issued from time to time by way of which the petitioner's scale was enhanced. The only grievance which the petitioner has, my lord, is the last scale of enhancement which was being granted by the authority that has not been given to the.
Please read prayer A, page 14. What does it mean?
My lord, in terms of this notification, my lord, the petitioner
I couldn't follow your first prayer. And annexure P6 amounting to rupees 4,05,452. What does it mean?
Well, lord, this is the amount which has not been paid to the petitioner in terms of this notification. If your lordship kindly
This is the prayer, then what relief you can expect?
Well, lord,
Nothing is clear from the prayer. What is this prayer?
Well, lord, this is the due which is in terms of this notification.
Here you have stated in the prayer.
Look, the amount portion, I apologize, my lord, for stating the amount portion. But as far as the notification is concerned, my lord, I am entitled to my rights in terms of this notification only.
Notification relates to what?
My lord, notification relates to an enhancement in my pay. I am a contractual worker, my lord. My enhancement was being granted by
Where
the
is the
commission.
notification?
My lord, the notification is at page 58, my lord.
It's a government establishment where notification is applicable.
Yes, my lord.
First paragraph of this notification, 1st of March 2024, relates to government establishment.
Yes, my lord. The question of enhancement of remuneration of casual contractual workers
In
engaged in
various
various
government
establishments.
establishments. In various
Yes, my lord.
government establishments. Is it a government establishment?
My lord, we fall within a government establishment, my lord.
How?
Your lordship will kindly take annexure P1 once, my lord.
How it is a government establishment? You are working in
West Bengal Comprehensive
Area Development
Corporation.
Authority. It's not a government
Development
establishment.
Area, my lord, annexure P1 at page 19, my lord. West Bengal Comprehensive Area
Yes.
Development Corporation.
My lord, I have only engagement of LR. No repetition is there.
The copy has not been served upon you. Why? It is to be forwarded from LR office.
My lord, only the letter has been forwarded.
Are you representing Area Development
No,
Authority?
no. My instruction is only the respondent number 1.
Where is the affidavit of service? Where is your affidavit of service?
My lord, my affidavit of service has been filed.
Clerk will file it in the court.
My lord, I initially only apologize, my lord. If your lordship kindly passes over, I'll come down immediately, my lord. I'm very sorry, my lord.
How it was refused? Show me.
Your lordship will kindly come to page 11, my lord, of the affidavit of service.
Why two affidavit of service?
My lord, there are two matters, my lord. So for this particular matter, there is one affidavit.
And in now I am
the
taking
affidavit of
only
service.
a writ petition WPA 28976 of 2025.
Yes, my lord. In that, I am showing your lordship page 10, my lord. The affidavit of service, page 10.
But in this case, two affidavits of service have been filed.
My lord, the first affidavit of service
Court will
was.
find out that which affidavit of
There
service
is only
will
one
apply
affidavit of
in this
service.
matter.
My lord, would kindly pass it over. My lord, would kindly pass it over. I'll immediately come down. I don't know why two affidavits of service have been filed. Lordship will kindly pass it over. I'll immediately come. 10 and 11, my lord, both the matters.
Show me how it was refused.
Your lordships has the affidavit of service, my lord, which is
yes.
Page 10, my lord, is the postal receipt. Page 11 is the status, my lord, which has been obtained from the website of India Post showing refused.
Page 10 consignment number is 2008. But page 11 consignment number is 8199 and also 2008. But it shows delivered. Book, dispatch, transit. How it was refused?
Is my lord having the affidavit of service dated 2nd of February 2026? My lord?
But it says Sej Bhavan IDC. Your office is at Raja Subodh Mollik Square, Office of
My
Responsible.
lord, the office had shifted from Raja Subodh Mollik Square to that particular place, my lord.
But
We were being informed by the client.
in the writ petition, you have given the wrong
When we had filed the writ
address.
when we had filed the writ petition, it was on the basis of the notification.
So where from
the office shifted.
court will come to know that you have sent it to the right address.
My lord, first we sent it to this address, which was refused.
In the writ petition, you have given the wrong address.
My lord, when we had filed the writ petition,
Leave is
the
granted to the lawyer
notification stated.
advocate representing the petitioner to amend the cost title and describe the address of authorities of Comprehensive Area Development Corporation being respondent numbers 3 and 4 appropriately by 6th February 2026. Stop. Next part. After such amendment is carried out, learned advocate for the petitioner is directed to serve notice upon respondent numbers 3 and 4, including amended copy of the writ petition and order passed by this court today by 10 days thereafter, and file affidavit of service on the next date. Stop. List the matter under the same heading for further consideration, or list the matter in the monthly combined list of March 2026.
In the meantime, if my learned friend give a copy,
Take back affidavit of service. There is another matter same.
Would
Call the
humbly
next matter.
request it.
Item number 11.
Similar issue?
Same, my lord.
Yes.
Similar issue, my lord. Similar orders, because there also the cost title needs to be amended.
Same order. 3 and 4 respondent. Yes, call the list. Item number 12.
12 minute I am for questions. But the petitioner ballot.
Yes.
But
So read petition can be entertained. Yes. It is already decided.
Are pursuant to an advertisement issued by the Food and Supplies Department, Malad, petitioner participated in the selection process for the post of Malad Sub Inspector. Malad, the petitioner appeared in all the phases of the selection process. Malad, name of the petitioner were recommended by the PSC. Thereafter, Malad, petitioner appeared in the medical examination and declared to be fit. In police verification, it was detected, Malad, one criminal case is pending, but due to that reason, Malad, my appointment is withheld. My lord, the criminal case which is pending, my lord, it relates to, my lord, mob violence, my lord, and which is pending since 2015. And petitioner, along with other 39, my lord, accused, my lord, have been implicated in the case, my lord, and the same is pending.
So if you are already accused in a criminal proceedings, how you will join the police force?
No, my lord, the sub inspector in Food and Supplies Department.
Or sub-inspector in Food and Supplies.
Yes,
So how will join the government force?
But it is such a not a heinous crime, my lord, and it is, my lord.
That is to be decided on conclusion of proceedings.
No, my lord, there are.
What is the present stage of the criminal case?
But the trial has not been yet commenced, my lord, since there are 39 accused. Out of them, my lord, some of the accused had already.
Show me that rule permits this. That when criminal case is pending against an prospective appointee, he can be appointed.
But the state at the discretion, my lord. But
Any provision.
But
the state has discretion.
But there are no, my lord, the rules, my lord. But I have got a decision of the Honorable Supreme Court, my lord. In the case of, my lord, Avtar Singh, my lord. But the Honorable Supreme Court has laid down the guideline with regard to the appointment where the criminal case is pending, my lord. My lord, may I hand over?
Please go through this order judgment and address this court on the next occasion.
Paragraph 38.
Supply the copies and address this court on the next one whether this will apply or not.
I mean, judgment citation.
Hearing of this matter record and order.
7 SCC 308.
In view of the judgment of this court dated 13 January 2026 passed in WPA 27327 of 2025 within bracket MD Masidul Islam versus the state of West Bengal and others. Present writ petition is found to be entertainable. So matter relates to appointment
2016.
Yes. In a post under the state government. Stop. Next paragraph. Hearing of this matter stands adjourned. List the matter under the same heading for further consideration on 24th February 2026. Go through and address this court whether this is maintainable or not. Who is for the state? You are not led by anybody. You are led by somebody or you are appearing alone? Where is Rama Halda?
Is not appeared.
But his name is recorded. Munshi, Mujia, Rahman and Rama Halda. Where is Rama Halda? Engaged in hospital.
Due to some person.
Or admitted in hospital. Mr. Sen, appear in this matter. Issue. Mr. Amol Kumar Sen, next paragraph. Mr. Amol Kumar Sen, learned additional advocate general is present in court, who is requested to appear in this matter on behalf of the state respondents. Engagement is not required to be regularized so far you are concerned. Stop. Go through the judgment, whether this judgment applies or not, on the anvil of the relevant rules, and apprise this court on the next topic.
I have heard it. একটা পিটিশনের কপি আর কি তুমি রিলাই করছো সেটাও না না তুমি পিটিশনের কপি দিয়ে এটা ফরওয়ার্ড করো মানে ম্যাটার উইল অ্যাপিয়ার অন
কবে ওটাকে দিলাম 24th February.
Item number 13.
This is that constable matter recruitment process where the list has been challenged.
Just a minute.
যেটা নোট করলে এটা যদি এক্ষেত্রে অ্যাপ্লাই না হয় তাহলে কি হবে যদি অ্যাপ্লাই না
Yes.
Our stand is that, my lord, the disclosure of the marks of written examination of the candidates before, my lord, completion of the entire exercise, including the viva votes, my lord, then that will, my lord, hamper practically the level playing field, and there would be, my lord, my lord, may I tell, my lord, if you lost, my lord, I rely upon one judge because, my lord, the UPSC, my lord, Public Service Commission, my lord, never it is followed, lordship, that the completion of the entire process. That if your lordship kindly have a look of this judgment also, my lord, it is, my lord, reported in 2022, 19 SCC, page 787. Now, my lord, there was 2022-19 SCC, page 787. My lord, there, my lord, the other points were also, my lord, cropped up, but the one of the issue was that unsuccessful candidate in written examination before the starting of viva votes, my lord, he, my lord, claimed many things, including the result of the, my lord, the written examination, the marks.
Court has not directed to publish individual results. Court has directed that a short list or the list of shortlisted candidates for the purpose of participation in PMT and PET. They are to maintain transparency. Marks allotted to the listed candidates and their category are required to be disclosed.
My lord,
I'm not saying
I'm very sorry, my lord.
directing you
My understanding, or if I go through your
publish
lordship's
result.
order, if your lordship kindly have a look, because it is their claim also. My lord, lordship kindly come to my lord, two paragraphs only. Paragraph 31 and paragraph 32.
Just a minute.
My lord.
দেয়া হয়েছে দেয়া আছে ওয়েবসাইটের নাম দেয়া আছে ক্যাটাগরি দেয়া আছে
লিস্টের ক্যান্ডিডেটের নাম দিচ্ছি না last minute. ইন্টারভিউ কবে শেষ হলো শিডিউল প্রোগ্রামটা আপলোড কর 60,000 ছিল my challenge আমার ক্যাটাগরি দ্যাট ইজ দ্য ক্যাটাগরিটা দিতে পারবো না ক্যাটাগরিটা দেওয়া যাবে না
Yes, what are the prayers? Come to pay paragraph 7.1, 7.7, 7.1, 7.2, and 7.3, page 790.
In Punjab, Haryana Superior Judicial Service rules, there is no condition regarding securing minimum marks in the main written examination, and the condition in the advertisement of securing minimum 40% or more marks in each paper for qualifying for a viva voce is contrary to the scheme of the rules. And then that is matter the paragraph 7.1 and then Lordship 7.2. Paper 5, criminal law was of 200 marks, but at the commencement of the examination, question paper handed over to the candidates was incomplete and it contained only 4 questions whose aggregate came out to be 160 marks instead of 200 marks as shown on the overlap of the question paper. But when the candidates made a complaint of
that is regarding handing over of question papers.
Question paper 1.
Then 7.3.
7.3. Despite repeated demands, respondents have failed to provide the marks obtained by the appellant in the written examination. Marks obtained by the appellant.
Here petitioners are not claiming marks. Petitioner is saying that they belong to a particular categories, but in the short list or in the list of candidates who would be permitted to participate in the next round of selection process, that list is bereft of necessary particulars.
Madam, kindly have a look.
So, in order to maintain the transparency,
kindly have a look.
disclose those documents. Yes, let us come.
Kindly page number 23.
Yes.
Petition.
So, therefore, the ambit of or the issue considered by the Supreme Court is complete on a different contours. That is not here. That is not the issue here. Please come to page 38.
Madam, page 38. Yes. Page
This is the list.
No.
List is page 104.
100.
Yes.
These are the categories, right?
Yes. Gender and serial number, nothing else. Which category, what are the marks obtained, nothing is disclosed.
Nothing.
Then
now we are, my lord, against it. We say that if we disclose it,
you may be against it, but court is not finding any anomaly in making such prayer to maintain transparency of this recruitment process.
May I tell one thing? There is no other, my lord, the only, my lord, the motive is that, my lord, that transparency, my lord, transparency must be, my lord, the stage wise. Let's kindly consider one thing. At this stage, transparency means, my lord, the loss of level.
If you more arguing on this issue, in order to make a submission that disclosure is not necessary, more court will be susceptible.
No, I am not on that.
More court will be susceptible in the during the environment of appointment by School Service Commission.
There is no room for that.
Yes,
the perception. There is no room for that perception. I also place this, my lord, the judgment, my lord. There is, my lord, the several aspects were there. One of the same.
But what was the prayer? That is not the prayer.
Disclosure.
Petitioners are not praying for publication of result. Petitioners being the aspirant for the post of constable under the category of home guard, they are seeking a direction for publication of a list of candidates as in page 104 with particulars that under which category these candidates are what are the categories of the candidate and the marks obtained by those
marks obtained. Now, my lord, there, my lord, the prayer was for, my lord, for individual who came up the court. Here, the prayer is not for his. He was already, my lord, as per the prayer in that matter, my lord, it has been redressed too. So for the petitioner is not satisfied. He says that for transparency, the marks obtained by all the candidates who, my lord, succeeded in written examination or my lord, selected for interview, all should be disclosed. It is his prayer. My lord, the prayer is at lordship page number, my lord, 23. And my lord,
Publish the respective marks category wise in respect of the candidates who has been shortlisted in annexure PA.
Yes.
Yes.
Now, my lord, that is, my lord, we against it, and my lord, lordship, my lord's order or direction was, my lord, on the last occasion, that what is the problem with regard to taking instruction on the, my lord, if I, my lord, go through that prayer. Now, my lord, what we said, exactly, my lord, that has been, my lord, said by the Honorable Supreme Court at paragraph 31 and paragraph 32. Lordship, kindly have a look once more, Lordship. Kindly have a look, my lord, for my satisfaction. Paragraph 31 and 32. What we say that, my lord, that will, my lord, on the very first day, I also said this.
Yes.
That before
Just paragraph 31 or 32 of this judgment.
31 and 32 of the judgment.
Just Now, what does your rule say relating to conducting recruit selection process?
My rule, does not permit this in this way.
Show me.
There is, there is, I think, the rules, my lord, I think whatever the, my lord, the advertisement also, my lord, it does not appear from the rule itself that it has to be disclosed.
Show me that where is the impediment in disclosing?
Page 29 onwards, rules law. এক মিনিট দাঁড়ান। না না, সেটা তো রুলস আছে তোমার এক্সামিনেশন কন্ডাক্টর, ইয়েস। It has been annexed to the writ petition also. It is silent.
Where from you are getting this? This is annexed to the writ
Yes,
petition.
yes.
Yes, which page, Mr. Sen?
Malab, it starts from page 27. It is of 2024.
Which rule is relevant?
We are at the stage of 5C, which is
5C.
Yes, method of recruitment.
page 29.
Yes.
No prohibition. Limited number of candidates.
Just a minute.
সবগুলোই থাকে। Mode of selection. And then it comes to an end at 7.
Why categories of the candidates are not disclosed? That is not prohibited as per Supreme Court judgment. Mr. Sen?
No, that is.
Please come to paragraph 32 of the judgment you are relying upon. Please read it.
To clarify further, in such cases where the written examination is followed with viva voce, declaration of result of the written examination before conducting viva voce may not be valid and justified. But in cases where determination of merit is based on written examination, it must be declared and made available to candidates without any loss of time, and this court can take a judicial notice of the fact that in such cases where the written examination is followed with interview, viva voce, and the members in the interview board are made aware of the marks secured by the candidates in the written examination that may likely to form bias affecting the impartial evaluation of the candidates in viva voce, and in our considered view, it may always be avoided.
Category?
Category, then also, my lord, to some extent, lordship,
that category is not. If you go by this judgment, in that event, there is no problem in disclosing category.
May I tell, my lord? Though, my lord, whatever I am told, my lord, I also asked this question.
It must be declared and made available to the candidates. Court is saying
yes
that to clarify further in such cases where the written examination is followed by viva voce. Declaration of result of written examination before conducting viva voce may not be valid and justified. But in cases where determination of merit is based on written examination, it must be declared and made available to the candidates without any loss of time.
Only written examination. There is
written examination.
Only no interview. No
yes,
second
because
stage.
in between written examination and viva voce, there is PMT and PET. Here. And if a candidate is wrongfully excluded, and thereafter, if that candidate has to wait till viva voce, then he will lose opportunity to participate in PMT, PET.
No, that is.
Then he will take this point that PMT and PET is over. So therefore, this is one aspect of the matter. It must be declared and made available to the candidates without any loss of time. And this court can take a judicial notice of the fact that in such cases, where the written examination is followed with interview vivos,
Yes.
and members in the interview board are made aware of the marks secured by the candidates in the written examination, that may likely to form bias affecting impartial evaluation of the candidates in vivavocy, and in our considered view, it may always be avoided.
His mark.
Here, it is not a selection process that the written examination is followed by vivavocy. Written examination is followed by PMT and PET. PMT and PET participation based on the result of written examination. So if today a candidate has to wait till a completion of vivavocy, then by that time his chance to participate in PMT and PET will be over. Gone. This is one aspect.
One aspect.
Second aspect is disclosure of category. Now in disclosure of category, there is no prejudice.
My lord, first of all, may I come again?
If it is a case of publication of marks in the written examination, then the members of interview board or vivavocy board may be prejudiced, having seen the marks allotted in written examination. But this has got no nexus with regard to disclosure of category in the list published for conducting PMT and PET.
May I come? First of all, my lord, may I just want to clarify with regard to that para 31 and 32 once more. My lord, the paragraph 31, it is stated that at what stage, my lord, the entire process is completed. At what stage? If it is completed at the stage or end of the written examination, there is no further process. Then written examinations number should be disclosed immediately. But if the process is not complete, that is halfway, it has to go any further. That means here PMT and my lord, other may not be PMT, but straightway interview. Then said that don't disclose because that should
It's not a straightaway interview.
It is a.
In the meantime, there are two stages.
Yes, there are two stages.
There are two stages.
But
Now, if the candidate has to wait till publication of till completion of vivavocy, in that event, by that time, chance to participate in PMT and PET will be over.
My lord, the candidates who are not selected for, they have been, my lord, informed about their.
Then why category is not disclosed?
Now, my lord, but
why category is not disclosed? So that they are to dispel doubt in the mind of the candidates that yes, I belong to OBC category. These are the candidates who have been selected under shortlisted in OBC category.
My lord, may I? Also, kindly give me, my lord, chance, my lord. My lord, may I? My lord, suppose, my lord, in the interview letter, the notice to appear, it appears to the candidate as well as to the interview board that the person who appears and put it paper as a candidate for interview, he is, my lord, OBC candidate. Another person comes after that, he is a general candidate. Another person followed him, he is, my lord, another, my lord, seal caste or, my lord, the reserve candidate. Now,
I am saying at first glance, having seen this list, it appears that how the reservation policy has been secured, ensured. It doesn't give any answer, having seen the short list. It is completely against all canons of the procedure relating to selection process. How the reservation policy has been implemented, it cannot be ascertained or deciphered from page 104.
Yes. No, it is correct. May I tell you?
Yes, sure.
May I tell you one
Yes,
thing?
I have heard you, Mr. Sen. Enough is enough.
Or, my lord, may I suggest one thing?
Yes.
My suggestion is that if I fail to pursue your lordship in this way, then my suggestion, my lord, is my instruction. Then I can put it in a seal cover before your lordship. My lord, the list with gradation, marks, everything, but in a sealed cover.
Court doesn't want to see, the aspirants want to see.
No, I do not, my lord, I only say that for the purpose of, my lord, what is, my lord,
that I could have done on the first occasion.
What is
Mr.
hovering in the
Sen.
mind? Also, kindly consider what is hovering in the mind of the petitioner, my lord, the court everywhere.
that with regard to, my lord, the sanctity of the, my lord, the process. But I say, my lord can test it after it. That what, but I can.
It is
but
not
we
the
don't
question of the court.
disclose it this way.
Court is raising question considering the case made out in the writ petition. But in order to make the entire process transparent and to dispel doubt from the minds of the petitioner, from minds of the aspirants, you need to disclose it.
Mind of the
Court,
aspirant.
I could have, Mr. Sen, I could have done it on the first day, directing the authority to produce in a sealed column, sealed paper or sealed envelope. That I do not want.
My lord, the mind of the candidates.
It is a list of. You have indicated a number 60,178
Yes.
shortlisted candidates.
Yes.
What court will do in 5 minutes?
No,
No.
I'm not on that.
Record or not.
My lord,
Pursuant to the order dated 22nd January 2026, matter is heard at length in presence of the learned advocate, advocates representing the petitioners and state respondents. Stop. Question, next paragraph. Issue is the recruitment notice is at page 36.
Yes. 36.
36.
On
36.
It's the first page. Thereafter, the main stages comes from 36 onwards. 36 is 36 is equal to 38.
issue is কি বলছিলাম issue in terms of recruitment notification dated 5th March 2024.
my lord,
6th March. It's
6th March, page 34 at the top right hand side.
5th March.
2024.
Yes, 2024.
Yes.
It's 2024.
examination also for 2020.
2024. In terms of recruitment notification dated 5th March 2024, for recruitment in the post of constable in West Bengal Police -2024, a written examination was conducted. Following the West Bengal Police within bracket recruitment of constables close bracket rules 2024, following the provisions of code, semicolon, and based on semicolon, based on such written examination, 60178 number of candidates were shortlisted by the concerned respondent, by the recruitment authority for conducting physical measurement test for short PMT and physical efficiency test for short PET. And Viva Voce. Though in said list containing names of candidates, though said list containing names of candidates is bereft of necessary particulars, that is, marks obtained by the candidates in written examination and categories of candidates. For example, you are SC, ST, OBC,
NDF, Home Guard.
comma, whether publication of such list is permissible or not. Next paragraph. Petitioners participated in the written test, being part of selection procedure in terms of aforesaid recruitment notification of 2024, সেন্টেন্সটি কি বলছিলেন? Under home guard category, all belong to home guard.
Yes, home guard.
Under home guard, under the category of home guard,
Belonging to different categories.
under the category of home guard. Stop. Petitioners also, petitioners belong to different categories such as you are SC, ST, OBC.
ST name.
You are SC, OBC.
OBC A, OBC B.
OBC A,
Paragraph
OBC
7
B.
of the previous order.
OBC
documents.
A, OBC B. It is contended by Mr. Lahiri, learned senior advocate representing the petitioners, that though list was published by the recruitment authority containing names of candidates who are to participate in PMT and PET, and lastly in Vaibhavosi, if they are found eligible. But the said list does not contain marks allotted to the candidates in respect of written test and categories of those and respective categories of those candidates. According to the petitioners, to maintain transparency, disclosure of these particulars now, according to the petitioners, disclosure of these particulars would maintain transparency in the selection process.
I've relied upon Aisha key also.
Stop.
One paragraph.
Reliance is stop. Reliance is placed. Where have you filed the judgment?
Yes, it is there. I think on the last occasion I've given a printout. SCC online printout, I think.
Just a minute.
কিসে রিপোর্ট হয়েছিল? SCC online.
Reliance is placed on the judgment of the Honorable Supreme Court reported in 2025 SCC online SC 719.
SC 719.
Within bracket State of West Bengal versus Boishaki Bhattacharya within bracket Chatterjee and others. Close bracket.
SCC online. SCC 719.
Stop. Next paragraph.
Mr.
Amol Kumar Sen, learned advocate representing Mr. Amol Kumar Sen, learned assistant or additional advocate general. Learned additional advocate general. Additional, Mr. Sen? Additional advocate general has opposed this writ petition and has made submissions that disclosure of marks of written test at the time of publication of list of candidates who are going to participate in Vaibhavosi may not be necessary. Stop. In this regard, reliance is placed on the judgment of the Honorable Supreme Court reported in 2022 within bracket 2022 volume 19 SCC 787 within bracket Harkirat Singh Ghuman versus Punjab and Haryana High Court and others. Close bracket.
Hello, one sentence more, Mala. That will affect the equal opportunity and level playing field between the candidates.
Stop. According to the respondent authorities, disclosure of marks of written test
Before Vaibhavosi.
at this disclosure of marks of written test prior to conducting Vaibhavosi would impact level playing field and
my lord, equal opportunity
and
among all the candidates.
and equal opportunity to
Before
all
the interview.
To the candidates
Before the interview.
who would participate in the in Vaibhavosi. Next paragraph. Submission of learned additional advocate general is chiefly based on the ratio of Harkirat Singh Supra. Stop. On perusal of the judgment of Harkirat Singh Supra, it appears appellant was an aspirant for the post of aspirant for the post of judicial officer and participated in Punjab Superior Judicial Service / Haryana Superior Judicial Service. Stop. Prayer was made prayer was made. Appellant being disqualified in the aforesaid or appellant being disqualified in the written examination by filing writ petition before the High Court of Punjab and Haryana at Chandigarh. Ventilated grievance that there was no condition regarding securing minimum marks in main written examination, and the condition in the advertisement of securing minimum marks in each paper for qualifying for Vaibhavosi is contrary to the scheme of the rules. Top grievance was also ventilated relating to handing over of question paper in phased manner, and prayer was made to provide marks obtained or to provide marks allotted to the appellant in written examination. Stop. While taking note of the grievance, taking note of the case made out, Honorable Supreme Court in paragraph 32 held that where written examination is followed with viva voce, declaration of result of the written examination before conducting viva voce may not be valid and justified. But in cases where determination of merit is based on written examination, it must be declared and made available to the candidates without any loss of time. And it was further held that in cases where the written examination is followed with interview/viva voce and members in the interview board are made aware of the marks secured by the candidates in the written examination, they may likely to form bias affecting the impartial evaluation of the candidates in viva voce and in our in viva voce. Stop. Stop. It is next paragraph. It is strenuously argued on behalf of respondent authorities that disclosure of marks at the time of publication of list for the purpose of participation in PMT and PET would impinge upon the procedure, a selection procedure, would impinge upon selection procedure, and that will have an adverse effect so far shortlisted candidates are concerned in viva voce. Stop. Next paragraph. Court is not ad item with the submissions made on behalf of state respondents, taking note of the observations made by the Honorable Supreme Court in Harkirat Singh Supra. Stop. In Harkirat Singh Supra, there was no other phases of selection process in between written examination and viva voce. But in the present case, at my hand, in between written examination and viva voce, there are two phases. That is, or there are two phases, namely PMT and PET. Stop. PMT and PET are to be conducted. PMT and PET will be conducted based on based on list published by the recruitment authority containing names of 60178 number of candidates. If candidates do not find place in the list published prior to PMT and PET, and if they do not come within the zone of consideration based on merit, which is assessed by holding written test, they will not be permitted to participate in PMT and PET. Therefore, it emanates. Written examination is the basis for participation in PMT and PET. Next paragraph, if court accepts contention of learned additional advocate general that list with all particulars shall be published after viva voce, in that event bona fide candidates may lose opportunity to participate in PMT and PET, which will be over by that time. Stop. Next paragraph. In view of aforesaid discussion, ratio of Harkirat Singh Supra does not come in aid of recruitment authority, as method of selection is different as it is contemplated under the West Bengal Police within bracket recruitment of constables close bracket rules, 2024. Next paragraph. In aforesaid conspectus and in order to maintain transparency in the selection process for the post of constable in West Bengal Police, which is being conducted pursuant to recruitment notification dated 5th March 2024, concerned respondent authorities are directed to publish list of shortlisted candidates with disclosing marks awarded to those candidates in written examination and their respective categories. For example, Home Guard,
NVF, Home Guard, SC, ST.
NVF, give me the details of category, Mr. Lai and Mr. Sen.
EC, page 38. You are EC.
That's page 38.
Yes.
Mentioned there.
No, first broader categories.
Broader categories are
Home Guard, General, then Home Guard.
Reserve, unreserved,
reserve,
then
unreserved.
unreserved EC.
Where from you are getting this?
My lord, at page 38.
Page 38.
My lord, at the top, first category.
For example, unreserved within unreserved
two.
within bracket UR
and EC.
Unreserved within bracket EC. Unreserved within bracket NVA plus HG close bracket. Unreserved within bracket ex serviceman. Unreserved.
Then my lord, better.
Yes.
Lordship mentioned that in terms of paragraph 38
better
better because there are so many
categories as mentioned.
categories.
কি বলছিলাম সেন্টেন্সটা বলো তো এত কথা বলা দরকার নেই. Disclosing or list of selected candidates করুন selected candidates
Shortlisted, not selected.
May I just make suggestion?
list of selected candidates for holding PMT and PET
The broad categories.
just a minute হ্যাঁ তারপর as delineated in page. This is part of this recruitment notice. As delineated in the recruitment notification dated 6th March 2024. Stop. Concerned respondent authorities are directed to publish the list in terms of aforesaid directions by 7 days.
I leave it to your lordship. I leave it to your lordship.
Because the interview is going on.
By 7 days from date. Stop. Next, with the aforesaid directions, writ petition stands disposed of.
Our submission always on the basis of the
Yes, what can be done? You have tried your best, and there is a judgment on it.
Keep your
Item number 14.
14, may I please, Your Lordship, I am for the petitioner.
We are the respondents.
This is my affidavit of service. That here my candidature has been rejected by the respondent authority on first instance, page 20 of my writ application. Two ground has been assigned. One is carrying angle greater than 15 degree, page 20 of my writ application. And hemoglobin. And page 21 is the review medical examination board's finding. Here also due to carrying angle greater than 15 degree. I have passed the hemoglobin, other ground has been assigned. But page 22 is the
Affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph, petitioner participated in the selection process for being appointed as Constable GD under Central Armed Police Forces. Stop. Petitioner qualified in written test and physical standard test, but in review medical examination, petitioner was declared unfit on the ground of carrying angle. Next paragraph. Union of India is represented by an advocate. Next paragraph. Concerned respondent authority is directed to file a report disclosing as to why petitioner was declared unfit in review medical examination based on revised medical guidelines of May 2015. Next paragraph. Next paragraph. Such report shall be let such report be filed by 3 weeks from date. Stop. List the matter under the same heading for further consideration on 11th March 2026.
Report by affidavit?
No,
Without report.
But you have to demonstrate that in terms of the review medical revised medical guidelines as to why petitioner was declared unfit.
I annex that.
Yes, yes. Item number 15.
Well, time for the petition. Affidavit of service.
For the respondent.
Mainly, my lord, kindly come to page 22. These are the prayers, my lord. There is, my lord, in the nature of mandamus directing respondent authorities number 125 to consider report submitted by the high-level committee dated 2/8/2018 and give revised promotional pay matrix in terms of the core principle of horizontal range, 7th pay commission by rejecting revised promotional pay under vertical range. And lordship, thereafter the representation which was done, lordship, made authorities to consider representation dated 14/11/2024 and allow grade pay notionally in the next higher pay matrix of 13th May of 8,900. And lordship, thereafter the pay matrix 13 would be our pay matrix where we should be placed. Now what has happened, my lord? We are the retired employees of DVC. But then, lordship, kindly come to the paragraph number 9 and 10. 9 is the information related to all the petitioners. But kindly come, the petitioners were promoted to higher post, assuming higher duties and responsibilities of the said organization based on their sincere performance and retired as a Group A employees.
What about the court fee? In respect of one issue.
But if it is not, then shall pay.
Affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph. Law and advocate for the petitioners prays for leave to deposit deficit court fees. Deficit court fees as at the time of filing the writ petition, court fee in respect of one petitioner was deposited. Next paragraph. Law and advocate for the petitioner shall be at liberty to put in deficit court fees by 7 days from date. Next paragraph. List the matter under the same heading for further consideration on 11th February 2026. Item number 16.
And Your Lordship, I am petitioner.
Lord, I am for the Union of India.
Here, my lord, that joint petition, Your Lordship, and liberty was given to the petitioner to file the reference. And this is my petition practice, and the petitioner before Your Lordship file the writ application. Here is the rounding off, my lord. The petitioner was
Rounding off means?
rounding off of the height. My lord, page 39 of my writ application, the authority measure my height 169.7 centimeter. This should be the rounding of 1 centimeter. My lord,
Where is my order?
I have.
Now that judgment has not been appealed against.
I have not received any copy of that. They have submitted before Your Lordship that they have prepared a appeal, but I have not. This is the original judgment, and subsequently considering the judgment part of. I have to.
Yes, my lord, only one thing, my lord. This judgment, this order that they are referring to, my lord, will kindly come to your lordship's judgment at page 21. Kindly see, my lord, paragraph number 2. My lord has proceeded on the to deliver this judgment on the basis of the assumption that in the middle portion, it is written, in all the matters, height of the petitioners is between 169.5 centimeter to 169.9 centimeter. Now, my lord, in the subsequent to this order, they have reappeared, and 169.7 is what it has come down to. So it would be rounded off to 170 as per your lordship's judgment. But my lord, kindly see this. They have said that they measure between 169.5 to 169.9. Kindly come to page 17, my lord. Page 17 of the writ petition. In the previous, they have suppressed this. Their height was not between 169.5 and 17.
Yes.
In the previous test, his height was 169.2. So
that is in physical standard test.
Yes.
Against which appeal was preferred.
My
in
lord.
Appeal, it was in page 39.
39 of my return.
In appeal, it was measured as 169.97.
Yes.
Yes.
As per this, they are supposed to get the benefit of that 170 as per your lordship's judgment. I am only pointing out one thing, my lord, that my lord has proceeded on the basis that everyone's height in that writ petition was between 169.5 and 169.9. But they did not follow within that group, my lord. They said their height was 169.2. They were not entitled to get that relief in the writ petition itself.
Why?
Because it was
finally the height of the petitioner was corrected, and it was stated, it was found at 169.7.
Yes.
So what is the final height?
169.7.
Your department?
169.7.
It needs to be rounded up to the next higher centimeter.
170. They will get that benefit. I don't doubt that, my lord. But the only thing I am submitting is they have proceeded on the basis that their height was 169.5 in the writ petition before your lordship, while it was not. Only this much, if it could be recorded, my lord.
It needs not be recorded, because if in the appeal it was detected that, or it was measured
169.6
less than 169.5, then then your point would have been accepted by this court. But in appeal, it was measured that the height of the petitioner was 169.7,
Yes, as per the judgment,
which is in between 169.5 and 169.9. So it is to be rounded up to the next higher centimeter in terms of the
170.
judgment goes through
As per paragraph 2D.
দাঁড়াও তো দেখি সিমিলার অর্ডার অনেকগুলো রিলাই করে বসো দেখে নিচ্ছি height was in physical measurement test 169.2. Yes. Just a minute.
39 is the final.
Now, where is the report of physical measurement test?
Yes, sir. That is page 17. That page 17.
Just a minute. Page 17, annexure P2. Where it is written?
Left hand side, height thereafter. Clause.
Yes.
Clause 5.
Yes. Within the table.
Within that.
In this case, there was no interim order. But you participated in the interview. You participated in the review, in the medical test.
Paragraph 6, your question.
Just a minute. Yes. Paragraph 6 will not be applicable here. So 169.7. আচ্ছা এসো তো এই প্যারাগ্রাফ 6 এখানে হবে না একটা প্যারাগ্রাফ অ্যাড করো petitioner being agreed by the measurement being agreed by the measurement made by the concerned respondent authority in physical standard test preferred appeal and finally and the appellate authority measured height of the petitioner 169.7 cm. এইটা 6 এর প্যারাগ্রাফে সাবস্টিটিউট করে দেবে আচ্ছা জাজমেন্টের কপিটা রাখার দরকার নেই কারণ ও অ্যানেক্স করেছে রিট পিটিশন অ্যাড করছি No. Yes, disposed of. Deep level. এটা দেখে করে দেবে, হ্যাঁ? এটা লাগতে পারে, ওখানে আরো কতগুলো আছে।
Item number 17.
Respondents. Same issue.
Same order.
Height.
No. Flatfoot.
But here my candidature has been rejected of past instance in case 22. In a bilateral flat foot, and page 23 is the also among the findings of the BMG code. Bilateral flat foot. Page 24.
But this is one of the grounds.
Yes, this is one of
Flat
the ground,
foot,
but
flat
I
foot
have
is one of the ground.
I have annexed the
As per medical guidelines.
As per the medical guideline, Mala, kindly have a look. The guideline I have annexed with the page 32 of my read application.
अब ये देखिए पेज नंबर 29 में लाइए
Page 32 of my read application. Past 7 minor acceptance. A mild flat foot. There is a rider. If the joint starter are flexible and are appeared on standing on the cheek toe.
ये हम लोग का है?
My lord, I have
वो लोग ही लगाए कॉलेज से जहाँ
and another portion, the detailed portion also says same thing. My lord, that is page 34 of my writ application. 34. If the joints are flexible and the arcs appear on the standing in the
Yes, yes, yes.
My lord, this is the thing. My lord,
Affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph. Petitioner participated in the selection process for being appointed as constable GD under Central Armed Police Forces within brackets CAPFS. Stop. Petitioner qualified in written test and physical standard test, but in review medical examination, petitioner was declared unfit on the ground of bilateral flat foot. Next paragraph. Union of India is represented by learned advocates. Next paragraph. Concerned respondent authorities directed to file a report disclosing as to why petitioner was declared unfit in review medical examination based on revised medical guidelines of May 2015. Stop. Let such report be filed by 3 weeks from date. Stop. List the matter under the same heading for further consideration on 11th February 2026.
Well, may I pray for a leave to file a supplementary affidavit, because after that I have obtained 2 more doctors' opinion that I have a mild flat foot. Well, liberty may be given to file that supplementary affidavit.
Not at this stage.
Well, in this petition, I have annexed also the document in support of 2 doctors.
Next.
Item number 18.
Madam. Get good.
এইটা না ফার্স্ট ম্যাটারে যেটা হাইটের উপর
But I am for the petitioner, madam. Our petitioner
Yes.
appeared for the post of constable. Subsequently, my lord, he was declared unfit by the DV.
Yes.
Initially, by the document verification and detailed medical examination, he was declared unfit. No reason was given.
Document verification declared unfit.
Lordship. Initially, he was declared.
Come to page 19.
Page 19 is the review medical board.
Yes. You
Review
are
medical
declared
board
unfit
also
on what ground?
hypertension.
It's a valid ground.
But valid ground, no doubt. But
Hypertensive candidate will be appointed in a disciplined force.
Lordship, but my lord,
providing security to the innocent citizens.
Lordship. But my submission with Lordship was that I am not suffering from any hypertension, because the medical guideline which has been published by the own department, that guideline has not been followed. Kindly see page 22 onward. Page 22 is the guidelines for recruitment medical examination in the Central Armed Police Force. And 23 is the relevant portion, 23 and 24.
Blood pressure is 140, 100, 150, 106.
Absolutely, but guidelines should be followed at the time of the measurement.
What guidelines? Show me.
Yes, I'm placing that guideline. Page 23, my lord, can you see?
Yes.
Once appeal is accepted, the competent authority details a medical board, and the medical board which examines such appeals should be as far as possible the one other than the medical board which initially examined the candidates as a basis on which he or she was declared unfit. Now can you see, my lord, the next second paragraph. for the defect for which the candidates has been declared unfit should be examined thoroughly and the findings must got supported by proper investigation reports if applicable. That is not there, number one. Number three, my lord,
In
can you see?
review medical guidelines of May 2015, it is provided specifically that if blood pressure is beyond the range, then the candidate is to be declared
But
unfit.
how the measurement?
Where is the review medical report?
How the measurement?
The report.
Nothing is required in this matter. Show me the review medical report, the provisions relating to hypertension.
And madam, give me one.
In all matters, report is not required. Where is the review medical report?
My lord, 140 blood pressure, 140.
That I have seen. That I have seen. Where is the review medical report? Yes, that is the review medical report. Please show, give it to me.
And page 23, can you see one for a moment? Page 23 again.
Find it out.
On page 23, can you see for a moment, but the last paragraph. Last paragraph, the guideline. Guideline says the four candidates who have been rejected on the ground of the hypertension. Can you see one for a moment? Can you see the guideline of their concerned department? They should follow it. My condition before lordship is that they have not followed it. The last paragraph E. For the candidates who have been rejected on the ground of hypertension should be admitted or hospitalized by the board before giving their final opinion regarding the candidate's fitness or otherwise. The hospitalization report should indicate whether the rise in the blood pressure of the transient nature due to the excitement, etc., or whether it is due to any organic disease. Page 24. Nothing has been annexed with the report.
to 100 এখানে 100 to 140 50 to 106 সেটা 60 to 90 হবে
Just a minute.
And page 24 by application, last paragraph also is there. The clinical findings should not serve the purpose.
Continue to remain high. Should be relaxed.
And can you see the last paragraph also by that?
File a report. Issue. File your affidavit of service. Where is your affidavit of service? Affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph. Petitioner participated in the selection process for being appointed as Constable GD under Central Armed Police Force System. Petitioner qualified in written test and physical standard test, but in review medical examination, petitioner was declared unfit due to high blood pressure. Next paragraph, Union of India is represented by learned advocates. Stop. Concerned respondent authorities directed to file a report disclosing as to why petitioner was declared unfit in review medical examination based on revised medical guidelines of May 2015. Stop. Next paragraph, let a report be filed by 3 weeks from date. Stop. List the matter under the same heading for further consideration on 11th February 2026. Take it back. এটা দিয়ে দাও।
Item number 19.
I am for the petitioner. This is my petition service.
You are working in ESI, under ESI authority. So you have to approach the Central Administrative Tribunal.
My lord, I am.
Why you have approached this court?
My lord, I am not challenging the contents of the merits of the so-called notices or the memorandums issued, my lord. My lord, this writ petitioner, my lord, was initially appointed in the post of ESIC pharmacist, my lord, in the allopathy department on probation. Within a month, my lord, I was transferred to the homeopathy department without any training. My lord, thereafter, my lord, which is mandatory in respect of the rules framed, my lord, which is mandatory. But my lord, at the petitioner was appointed, my lord, yet within 1 month, my lord, he was transferred to the homeopathy OPD pharmacy without qualification, training or consent. And my lord, subsequently, my lord, I prayed for several times to.
This matter relates to your service of service concerning transfer. You have also made a prayer for sure. Questioning the show cause notice warning issued without jurisdiction and in violation of principle of natural justice. Issue relates to your service. Come to section 14 of the Administrative Tribunal Act 1985.
What I am on, my lord.
On and from the date from which any jurisdiction, powers and authority becomes exercisable under this act by tribunal in relation to recruitment or matters concerning recruitment to any service or post or service matters concerning members of any service.
That is
the moment he relies upon the service rules, it touches the condition of
touches upon the domain of service.
My lord, this section 14 and 16 of the article 14 and 16 of the Constitution of India, my lord, I have not been heard, my lord. DOPT
article constitutional point in L. Chandra Kumar in read paragraph 91 onwards. It was succinctly decided by the Honorable Supreme Court that constitution point can be agitated before the tribunal. That was one of the issues before the Honorable Supreme Court in L. Chandra Kumar, accepting virus of the parent statute under which tribunal is constituted.
Kindly gives me liberty to approach the
yes,
forum and
yes.
Your, limitation will, if your lordship finds
limitation will be considered on merit, my lord.
You are employee of ESI corporation. Affidavit is filed on behalf of the petitioner is taken on record. Next paragraph. Petitioner is working under Employee State Insurance Corporation, which comes under the purview. Now, corporation and service of the petitioner comes under the purview of Administrative Tribunal, purview of the relevant provisions of the Administrative Tribunal Act 1985. Stop. Therefore, a writ petition at this stage before the High Court is not maintainable. Stop. Next paragraph. Petitioner is একসঙ্গেই করো stop. The petitioner is required to approach Central Administrative Tribunal. Next paragraph. Writ petition stands dismissed as it is found not maintainable. Stop. Next paragraph. However, this order shall not preclude the petitioner to approach Central Administrative Tribunal on the self-same cause of action. Parties to act on the server.
Limitation party.
No, no.
Item number 20.
Item number 20, Mr. Hon'ble ID Senior Advocate is appearing in this matter. My lord, he's on his legs before court number 11.
State.
Short passover.
My lord, this application is barred by limitation.
They will come back not today.
My lord, then makes it, my lord, kindly makes it day after tomorrow, if it commenced to your lordship.
Very well. No, day after tomorrow, as Mr. Bose is praying for.
My lord, great.
Not today and tomorrow.
Great.
Item number 21.
My lord, item number 21, I beg to appear on behalf of the petitioner.
Not
for the union of.
My lord, this matter, your lordship kindly, my lord, on 20, on 3rd September, my lord, 25.
Yes.
Am I audible to your lordship, my lord?
Yes, audible.
Yes. My lord, on 3rd September 25, I appeared for the physical measurement test. And my lord, I was subsequently declared not qualified because my height was 169.2. Then my lord, on 6th September 25, I preferred an my lord representation because on that same date I couldn't my lord prefer an appeal. My lord, then that was my lord rejected and we
Yes.
We came back before your lordship, my lord, and we preferred an writ application. Your lordship, my lord, page 29, your lordship's directions are there. Your lordship, my lord, directed the respondent authority to consider my representation. And now, my lord, subsequent to that, we preferred another appeal before the concerned authority. They measured my height, and now my height, my lord, if your lordship kindly takes up, according to their measurement, my height is
page.
I'm coming, my lord. Page number 34. 169.8.
Yes.
And now, my lord, then also, my lord,
what was your initial height as per measurement taken in physical standard test?
169.2.
Which page?
My lord, kindly takes up.
169 point?
Page 16, lordship.
এটা ভালো লাগছে না তুমি এটা কথা বলো 169.2
Yes, my lord.
Page
20.
Yes, 169.2 in appeal it was measured 169.8.
8. And my lord, your lordship, my lord,
what you are praying for?
My lord, now, my lord, we had the pleasure of assisting your lordship in a matter wherein your lordship has held that order has also been annexed. That, my lord, if we, my lord, in terms of the rules, if we are beyond 169.5, we will be held to be qualified.
Yes.
And that, my lord, direction and, my lord,
Any
judgment
appeal against that judgment?
My lord, no copy has been served. Now, my lord, I don't think, my lord, any appeal so far as my subject to correction definitely from
now,
my
where is the order? I have passed
35,
upon my own judgment.
Page 35, my lord.
No, that is the main order, parent judgment.
Yes.
But subsequently, I have a order pass করলাম কে নিলে বলো তো?
I think, my lord, in Mr. Kormokar was assisting your lordship.
এর আগে মনে হয় নিল না?
My lord, I think, my lord, item 17 or 16, something like that, my lord.
There are orders I have passed relying upon my own judgment. Where are those orders?
My lord, I don't have a copy. If your lordship wants me to come back, I can definitely come back, my lord.
Lordship, there are also some discrepancies. We need to file a report in this. Let's say if passes an order for the report, because here the matter requires a report from the department.
Nothing.
Lordship, if it comes to page number 28, they rely on a document that from the government.
Height of the petitioner was measured 169.7. So it is to be rounded up to the next higher centimeter. I have decided by delivering elaborate judgment.
Lordship.
Nothing. If the issue is no more res indica, only you may have preferred an appeal. Let my judgment be tested before the honorable division. একটু ডাকো তো ওই অর্ডারের কপিটা একটু আনলে সুবিধা হয়, নাহলে আবার আমার ডিকটেশন মধ্যে নো ফার্দার রিপোর্ট। And in one of the matters, Honorable Supreme Court has passed an order on 16 January 2026, affirming the view adopted by the Bombay High Court, which supports my view. Only there is one divergent view expressed by Madhya Pradesh High Court.
Madhya Pradesh.
Yes.
But that, my lord, we have also in that when
in Arun Kalmodia's matter.
Gotcha.
Yes. That was referred by Mr. Lahiri, my lord, in the.
অর্পণ ওই হাইটের ম্যাটারটা একটু সিমিলার ইস্যু আছে, সেম মানে নিয়ে নাও, ওই অর্ডারটা ধরেই করে দেবে, শুধু হাইটের মেজারমেন্টে যদি ডিফারেন্স হয় দেখে নেবে। আমার মতে হাইটটাও এক 169.2, ইনিশিয়াল হাইট ওয়াজ মেজার্ড 169.2 and in appeal it was measured 169.8. No, it was 169.7. 7 chule 169.8. Rest of the order will remain same. Have you annexed the order of the judge? Have you annexed my judgment dated 3rd January?
Yes, my lord. 3rd January, no, my lord. 3rd January.
It is judgment 18 December 2025, right?
That I have annexed, my lord.
You have annexed. সুতরাং ওটা দরকার নেই তোমাদের ওই।
That is at page 35, my lord.
হ্যাঁ, কি পড়ো সেন্টেন্সটা। You formally preferred appeal or you made representation?
My lord, in terms of your lordship's direction, I made my lord, that is also there. If your lordship, my lord, if I can use the term, it is pursuant to your lordship direction, it was an representation in form of an appeal.
It needs to be ওই প্যারাগ্রাফটা, যে প্যারাগ্রাফটা আমি অ্যাড করলাম, it needs to be recorded herein that finally height of the petitioner was measured 169.8 centimeter at the time of considering representation of the petitioner by the concerned respondent author.
That is at page 31. I have termed it as representation.
They have not preferred any appeal on
directed. This court directed to consider the representation. Where is the order passed by this court on previous occasion?
My lord, the December order, my lord, is referring to the judgment. Yes, my lord, it is the last, and my lord, I'm coming, my lord.
Lordship, the November's order in page number 20.
No, your representation was directed to be considered by this court. Where is that order?
Oh, my lord, that is there, my lord. I'm just coming.
Page number 29, Lordship.
29. I'm thankful to my learned friend, my lord. Page 29 was also there.
Disposed of next.
Grateful, my lord.
Item number 22.
My lord, I beg to appear on behalf of the petitioner.
Yes. But we are the
Signing my
respondent.
affidavit of service.
Yes.
Initially, my detailed medical examination was rejected. I was declared unfit due to diverted nasal septum, tachycardia, and scar mark. Now, in review medical examination at page 31, Lordship will find that DNS has been held to be mild, and that has been
paper with the paper with paper.
page 31 is my review medical examination, Your Lordship. Trivial tricuspid regurgitation, and there is a right inguinal lymph node. Lordship has
To relating to heart ailment.
Lordship, I have got myself tested.
Tachycardia.
Tachycardia that has been
The
held
high
to be
heart
trivial
rate.
tricuspid. No, in review medical board, it has been held to be trivial tricuspid regurgitation.
Yes.
That has been, I have undergone echocardiography. Your Lordship will find the report at page 38.
But what was the position at the time of review that is to be taken into consideration?
Lordship, I have been, there has never been any history of any heart problem with regard to my.
Who will consider it and decide it?
2024
Whether the court will decide it, you had never.
2024,
Even you,
I have
you being the advocate of the petitioner does not know. You do not know
I am relying on their document in
that whether the
2024
petitioner
I
had
was
heart
examined.
problem or not.
The Lordship, in 2024.
Who will decide it? At the time of review medical examination, it is found that petitioner is suffering from high heart rate, then he is not entitled.
Initially in 2024, there were 3 conditions in detailed medical examination. There were 3 defects were found. In review medical board,
You
all
can be appointed in a civilian post or in a civil post. But in discipline medical, in discipline medical force, you cannot be appointed.
In my respectful submission, tachycardia is
Because
not something
it
which
depends
comes up.
upon your physical ability
No, Lordship,
and physical endurance.
I bow down.
So
Your
how
Lordship,
this
kindly sees
with
page
this
41.
heart ailment you can be appointed?
Kindly sees page 41 once. For my satisfaction, kindly sees page 41 once. I am backed by echocardiography, which says that everything is normal. Still, I am relying on page 41, Your Lordship.
The parameters of assessing medical fitness by a hospital or physician and the medical expert in review medical examination for recruitment in discipline force is completely different.
Different. The yardsticks
And
are different.
here the rigor is it is more strict.
Absolutely.
In the true sense of the term. That's
Absolutely.
why it is to be conducted. Medical test is to be conducted in terms of review medical guidelines. So therefore, in normal physician or the government medical hospital may have certified you, but that does but in case of heart ailment, when the medical expert in review and detailed medical examination are required to follow the medical guidelines of May 2015.
Two things I will submit, Your Lordship. First is that
they cannot avoid the rigor of medical standard, which is prescribed by the experts.
With regard to medical, if there is a defect, if I do not come within a particular guide, within a particular range, then that will come up with from the investigation reports.
Now the investigation reports, whether there is
What
any
will
existence of
happen
any
I am telling you, after doing our service for 1 year, he will pray for easy post.
lordship, that
Sorry.
Lordship kindly says
He
there
will pay
was
for easy post because of his health issue.
Lordship,
It is not possible.
So, Lordship, today if I have a if one of my valve is blocked, that will come up in the review medical board. Even if I get myself examined in a separate independent hospital, that will be there.
You obtain an instruction, written instruction, come back. I will not call for any report here. Yes.
So, Lordship, kindly
Affidavit of service filed on
kindly-
behalf of the petitioner is taken on record. Next paragraph.
with regard to the
Petitioner
start, Lordship, there
participated
was
in the review medical examination. And a petitioner participated in the recruitment process for being appointed as Constable GD under Central Armed Police Forces. Stop. However, in review medical examination, petitioner was declared unfit due to trivial tricuspid regurgitation. Stop. Learned advocate representing the learned advocate representing Union of India is directed to obtain written instructions by 7 days from date. Stop.
and the findings
The
of
matter
the review.
under the same heading for further consideration on 13 or further consideration on 13th April. Today is 3rd. Well, 13th Friday. 12th February 2026.
Lordship, this has been done on the basis of an investigation report.
No, sorry, I am not impressed. Sorry.
Not that, let that report be produced. With the instruction, let that report be produced.
No, sorry.
The
Yes.
investigation report.
No.
Item number 94 from monthly list of appellate side.
I am for the petitioner.
My lord, I am appearing on behalf of state, my lord.
आप कराने से एक तुम्हारा मामला रुक गया।
Yes.
May I allow to submit my instruction, my lord, before your lordship?
Yes. What is the instruction? Tell me.
Basically, my lord, on
December
11th December 2023,
Yes.
the application of the petitioner was rejected by the Sub-Regional Employment Exchange, Havda. As per the clause 5 of the memorandum, memo number 175 EMP dated 29th August 2013, my lord. What is the clause 5, my lord? Clause 5 is the eligibility criteria.
File it. Let me see. That a copy. Yes.
My lord, please come to the paragraph number 1. That the petitioner is not enrolled in the employment bank. However, the petitioner was provisionally enrolled with temporary enrollment number TMP so and so, my lord, on 9th December 2023.
Found in details submitted by the petitioner, understanding current verification. Regional employment exchange hub. And the sector action mismatch found submitted by the petitioner. Your employment under your enrollment was provisional, but subsequently it was found that there was mismatch. Now it is stated that it is further under Juboshri scheme is strictly governed by resolution number so issued by Labor Department, Government of West Bengal. Clause 5 of the said resolution mandates that only applicants with valid and confirmed enrollment in the employment bank as a job seeker are eligible. As per clause 9, selection is based on first come first served basis.
Yes, madam.
So your enrollment was not appropriate in employment bank as job seeker.
Milord, my humble submission is that they
My lord,
provisionally
it was intimated to the petitioner on through SMS.
SMS. I have gone through the petitioner gone through this employment exchange. It was never informed him to repair some defects in their petitions.
No, it is stated that a petitioner is not enrolled in the employment bank. However, petitioner was provisionally enrolled with temporary enrollment number. Number is disclosed. TMP so on 9 December 2023. Such provisional enrollment was subject to verification of the particulars furnished by him, underscoring the critical role of accurate enrollment in determining. Upon due verification of said provisional enrollment was rejected on 11 December 2023 by the Sub-Regional Employment Exchange Howrah on account of information mismatch found in the details submitted by the petitioner under. The said rejection was duly communicated to the petitioner via SMS.
This was not, the detail was not written by SMS only, and I have not given a chance to PQ it, matter. Your lordship had given a chance, and I have already cured it, the petition, matter.
issue. A report is filed on behalf of by Mr. Sahi, learned additional government leader, representing state respondents, which is signed by the Special Director of Employment on 29 January 2026, and same is taken on record. Stop. Next paragraph, on perusal of report, it appears, on perusal of said report, it appears that petitioner was not enrolled in the employment bank, EB Capital. And the petitioner was not formally enrolled in the employment bank. Stop. However, petitioner was provisionally enrolled with temporary enrollment number as disclosed in the report on 9 December 2023, subject to verification of particulars of the petitioner. Stop. As per report, it appears that on due verification, provisional enrollment was rejected on 11 December 2023 by the Sub-Regional Employment Exchange Howrah due to information mismatch. Subsequently, said rejection was intimated to the petitioner by SMS to petitioner's registered mobile number as a result whereof enrollment status of the petitioner was not confirmed. Stop. Next paragraph. Eligibility for unemployment assistance under Juboshree scheme, YS capital, under Juboshree scheme is strictly governed by resolution dated 29th August 2013, issued by the Labor Department, Government of West Bengal. Stop. Clause 5 of the said resolution requires only applicants with valid and confirmed enrollment in the employment bank as a job seeker are eligible. Stop. Are eligible. Stop. Next paragraph. As it appears from the report dated 29 January 2026 that petitioner was not appropriately enrolled with the employment exchange as job seeker. Therefore, benefit of যুব উৎসাহ প্রকল্প within bracket YUP bracket close YUP bracket close hyphen 2013 slash কি বললাম সেন্টেন্সটা? Now, therefore, petitioner is not entitled to get benefit of or benefit under যুব উৎসাহ প্রকল্প within bracket YUP close bracket hyphen 2013 slash যুবশ্রী. Stop. Next paragraph. Hence, no relief can be granted to the petitioner. Writ petition stands dismissed. Urgent xerox certificate.
Highly obliged, my lord.
Next.
Item number 95.
95, Lordship, I am for the petitioner, Lordship. In
For the state, my lord.
My client Sophosai Charity is leading this matter, Lordship. He is unable to come through this court. He's on his leg in another court, Lordship. Kindly give up 1 day accommodation, Lordship.
For state. Is record an order at the time of call. At the time of call, accommodation is prayed for on behalf of the petitioner. State. On the ground of learned advocates. Stop. Next paragraph. However, state respondents are represented by learned advocates. Next paragraph. List the matter under the same heading in the monthly combined list of February, March 2026. Next. March.
Item number 96.
96, my lord, the petitioner had been an employee of West Bengal Transport Corporation Limited. Retired on, my lord, March 31, 2024, praying for interest on delayed payment on only Provident Fund.
When retired?
March 31, 2024.
31st March 2024.
2024.
Under GPF or CPF? You are not aware?
No.
What you are praying for?
My lord, West Bengal Service. My lord.
Yes. West Bengal Transport Corporation.
Praying for interest on delayed payment of Provident Fund.
Only Provident
Only
Fund.
Provident Fund.
Malaj, on the last occasion, there was a direction to serve upon the state. Because
Lord, I have served and filed the executive service.
yes, the state, my lord, is the fund-bearing authority.
If state does not appear, what?
My lord, I'm only, yes, my lord, I'm only pointing out, my lord, one mention may be there in this order.
Just a March. 31st March 2024. West Bengal Transport Corporation. Whether the petitioner was under Contributed Provident Fund scheme, are you aware of? Whether the petitioner was under the Contributed Provident Fund scheme?
My lord, the petitioner was under the
Contributed Provident.
Yes.
Yes, same order. এটা দেখে নেব কালেকশন আছে দু একটা ডিসপোজড
Item number 97.
আচ্ছা উপরে দিতে এফিডেভিট অফ সার্ভিস ফাইলড অন বিহাফ অফ দ্য পিটিশনার ইজ টেকেন অন রেকর্ড স্টপ আর একটা লাইন অ্যাড করে ইন স্পাইট অফ সার্ভিস অফ নোটিস স্টেট রেসপন্ডেন্টস আর নট রিপ্রেজেন্টেড ঠিক আছে
My lord, in this matter, my lord, I have raised an objection.
Just yes. What you are praying for? What is your case? Tell me. Retired on 31st of March 2021.
My lord.
My lord,
When retired?
February 29, 2020.
Oh. Just 28 February.
29 February 2020.
29 February
2020.
2020. Yes.
My lord, praying for the interest on delayed payment of the entire retirement benefit.
What are the retirement dues? What are those retirement dues?
Provident fund, gratuity and leave encashment, leave salary.
Gratuity and leave salary.
Gratuity and leave salary.
Yes, what is your objection?
My lord, my objection is with regard to the limitation of 3 years that has been followed, my lord, in the other cases, my lord, which in cases of Tarsim Singh and my lord as
yes,
and my lord,
it's not a case of affecting right of a third party.
Yes, my lord, it has become a case of affecting a right of the third party, my lord, I'll show. My lord, on similarly placed employees, my lord, of the same corporation have been, their cases have been dismissed by orders of this honorable court itself, my lord. My lord, as such, my lord, there have been number of employees who have not been given any interest after if they have made a claim after the expiry of the limitation of 3 years, my lord. My lord, now if a different judgment is, my lord, pronounced and a different stand is taken, my lord, it will open floodgates and my lord, it will result into chaos.
You have made the delay in releasing the benefits.
My lord,
and you have enjoyed the corpus.
My lord, I agree.
Without making payment.
Yes.
Why the retired employee will suffer?
My lord,
and will not get the interest?
My lord, the interest, my lord, the petitioner, if my lord, the petitioner would have claimed within the period of 3 years, my lord, I would have bowed down before your lord.
How that is permissible?
My lord,
in the case where there is no creation of third party interest.
My lord, the third party interest has been created already by the conduct of the
How
of both the
where
parties.
is the question of creation of third party interest in the
lord,
matter of payment of pension and interest?
My lord, this is not a matter of pension, my lord. This is a
Interest,
matter of
how third party right
benefits
is
of
affected?
My lord, I am just trying to indicate, my lord, that since there have been already judgments in which
No, please. Now, instead of judgment, you demonstrate that how third party right is affected.
My lord, I shall demonstrate, my lord.
If
My lord,
it is a case of appointment.
Yes, yes.
Suppose a selection procedure is questioned. Now, in the meantime, new incumbent has been appointed. Subsequently, if that selection process is considered by the court and is declared null and void, in that event, newly appointed candidates' right would be affected with regard to employment. It is not that case. It is not that case.
I understand, my lord. It is not
and it's
that.
a continuing cause of action.
My lord, I also differ on that point, my lord. May I demonstrate, my lord?
Have you brought the judgment of Tarsim Singh?
My lord,
There, the delay was aptly considered by the Honorable Supreme Court.
Yes, my lord, I am considering.
Yes, show me Tarsim Singh judgment. Gosh. When these return dues were paid?
July 2020.
When it was paid?
Yes,
Retired on 29 February 2020.
he was paid on 14th July 2020.
July 16, 2020 and July 14, 2020.
Yes.
July 14 and July 16.
July 16th and July 14th.
issue. Petitioner was an employee of West Bengal Transport Corporation who retired on superannuation on 29th February 2020. Stop. After superannuation, petitioner was paid. After superannuation, petitioner was not paid interest. Now, petitioner was not paid retirement dues. That is Provident Fund, gratuity and leave salary within time. Stop. Petitioner was paid aforesaid benefits due to superannuation on 14 July 2020. Stop. By presenting this writ petition, petitioner has claimed interest on retirement dues. Stop. Next paragraph. Such claim of the petitioner is opposed by the learned advocate representing West Bengal Transport Corporation on the ground of delay. Stop. It is submitted that petitioner ought to have approached this court claiming interest within 3 years from the date of arising cause of action, claiming interest, failing which petitioner is not entitled to claim interest. Next paragraph. During course of argument, both the learned advocates representing the parties have relied upon judgment of the Honorable Supreme Court reported in 2008, Volume 8, SCC 648, within bracket, Union of India and others versus Tarsem Singh, close bracket. Stop. In paragraph 7 of Tarsem Singh Supra, it was observed that belated service related claim will be subject to the ground of delay and laches. Subject will be belated service related claim will be rejected. Sorry, belated service related claim will be rejected on the ground of delay and laches. Stop. However, continuing wrong was found to be an exception. Stop. Where a service related claim is based on a continuing wrong, comma, relief can be granted even if there is long delay in seeking remedy. Stop. It was also observed therein that if the grievance is in respect of any order or administrative decision which related to or affected several others also, and if the reopening of the issue would affect the settled rights of third parties, comma, then the claim will not be entertained. Stop. It was also observed. It was further observed that in case of consequential relief of recovery of areas for a past period is concerned, comma, the principles relating to recurring / successive wrongs will apply. Stop. As a consequence, comma, the High Court will restrict the consequential relief relating to arrears normally to a period of 3 years prior to the date of filing of the writ petition. Next paragraph. The case at my hand is not recovery of arrears based on consequential relief. Stop. Admittedly, there was delay on the part of respondent authorities in releasing retiral dues. Stop. Respondent authorities got the benefit of keeping the corpus with them for an extended period. Consequently, petitioner could not utilize the fund even though he retired, even after his retirement. Stop. After his retirement. Stop. Delay in releasing retiral dues is attributable to the respondent authorities. Furthermore, it is not a case of affecting right of third party. Stop. Next paragraph. Hence, respondent authorities, concerned authority of West Bengal Transport Corporation is directed to pay interest at the interest on provident fund, comma, gratuity and leave salary which was belatedly paid to the petitioner at the rate of 6% per annum from the date following the date of retirement till date of payment. by আগেরটা কত মাসের মধ্যে দিতে বলো তো? তুমি নিলে তো 3 months বললাম, দেখো তো। দেখি আগের অর্থ দেখি। By 3 months from the date of communication of this order. Next paragraph. 3 months from the date of communication of this order. Stop. Next paragraph. In the event concerned, a respondent authority fails to pay interest on the retirement dues in terms of the aforesaid directions within the stipulated time, comma, respondent authority shall be required to pay 8% interest per annum on deferred payment. Stop. Next paragraph, with the aforesaid directions, writ petition stands disposed of.
My lord, one sentence may be recorded. My lord, may the state authorities be directed to release the funds.
State is not represented, sorry.
My lord, but state is a party, my lord. The state is the fund disbursement authority.
না না আমি ওখানে ডিসকাস করে দিয়েছি না
My lord, the state is the fund disbursement authority, my lord.
Yes, next.
Item number 98.
My lord, I am appearing for the state.
Yes.
My lord, similar retired on my lord January 31, 2020. Interest on delayed payment.
Yes, when retired?
January 31, 2020.
31 January 2020.
Interest on delayed payment of the entire retirement benefit.
Interest on?
Delayed payment of the entire
Interest on Provident Fund gratuity leave salary. Yes.
Well, the state is represented at least in this one, my lord.
Yes, here I will direct. Where state is represented, I will direct. Shonu. Give another copy of the order, in the first matter, which order we have given. Do you have a copy? বার করে নিতে বলো তো ওটা বার করে নাও ওখানে থাকুক ওটা বার করে নাও ইয়েস ইয়েস ওই তো দিচ্ছ হুম Affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph. না এটা কারেকশন করে দিই বুঝতে তো আচ্ছা ওর অবজেকশনটা একটু রেকর্ড করুন। The West Bengal Transport Corporation is represented, West Bengal Transport Corporation and state respondents are represented by learned advocates. Next paragraph. Learned advocate representing the corporation has opposed this writ petition on the ground of delay, as petitioner retired on superannuation on 31st January 2020, whereas present writ petition was filed in 2025. Stop. Next paragraph. The point of delay in the matter of giving direction to grant interest on retirement dues in case of retired employees of West Bengal Transport Corporation is decided in WPA, ওই আগের ম্যাটারটা যেটা করলাম, in WPA so and so of so and so, তারপরে ওই নেম অফ দ্য পার্টিস ভার্সেস করবে। Stop. Therefore, there is no need to dilate on this issue. Dilate, D-I-L-A-T, dilate on this issue. Stop. দাঁড়াও দাঁড়াও দাঁড়াও, নিয়ে যাও। If necessary, state respondent shall release requisite fund. State is represented. তুমি ওইটা শুধু অ্যাড হবে আর এই প্যারাগ্রাফ গুলো অ্যাড করে দিবে, এগুলো থাকবে। এইটা তো বলে দিলাম তুমি। West Bengal State Transport Corporation and the state respondents are represented. Disposed of.
Item number 99.
Same issue.
Same issue, my lord, retired on July 31, 2018.
Retired July
31, 2018.
Interest
on my lord, provident fund, gratuity and leave salary. Delayed payment.
July 2018. Retired করে নাও। এখানে ওয়েস্ট বেঙ্গল ট্রান্সপোর্ট কর্পোরেশন ইজ and the state, whether state is represented না, ওয়েস্ট বেঙ্গল ট্রান্সপোর্ট কর্পোরেশন ইজ, এটা তাহলে ঠিকই আছে, রিপ্রেজেন্টেড বাই লয়ার। এবারে ওর যে অবজেকশনটা, ওটা আগে যেটা বললাম ওইটা রেকর্ড করে নেবে। হ্যাঁ, অবজেকশনটা রেকর্ড করে নেবে, আর যে ইস্যু ডিসাইডেড ইন প্রিভিয়াস ম্যাটার ওটাও রেকর্ড করে নেবে, হলো? তারপরে সিন্স ইট ইজ ফাউন্ড দ্যাট দ্য ওয়েস্ট বেঙ্গল ট্রান্সপোর্ট, এটা থাকছে 8% ডিফল্ট ক্লজ, এটা থাকছে না, স্টেট অ্যাপিয়ার করছে না, ডিসপোজড অফ, ঠিক আছে, এটা থাকছে। হ্যাঁ, অবজেকশনটা যেটা বললাম, হ্যাঁ, previous matter, relying upon previous matter, this order is being passed. Further issue need not be dilated further, যেটা বললাম। Yes, disposed of.
Item number 100.
গুলো ম্যাটার আছে, অনেকগুলো ম্যাটার। This is the main difficulty in interest matter. Once you pass an order, several orders you have to pass.
This is exactly why I was pointing out that by the conduct of the court and by judicial orders, my lord, third party rights have already been created.
Yes, yes, yes.
My lord, retired on September 13, 2021.
September 13, 2021. It is better case. 2021, yes. 30th September 2021.
13 September.
1-3.
1-3.
Interest on?
Interest on, my lord, provident fund, gratuity and leave salary. Entire.
And leave salary.
Leave salary.
State is not represented. শোনো, যা আছে তাই, এটাই হবে, শুধু ওই প্যারাগ্রাফটার অবজেকশনটা আর ওই আমার অবজারভেশনটা। হ্যাঁ, শুধু ডেট অফ রিটায়ারমেন্ট আলাদা, ডিসপোজড অফ।
Item number 101.
My lord, I am for the petitioner, my lord.
Retired on December 31, 2020.
My lord,
31st
petitioner,
December 2020. Interest on inter-retirement. সেম হবে, ডেট অফ রিটায়ারমেন্টটা চেঞ্জ হবে, সেম অর্ডার দেখে নেব, ডিসপোজড অফ।
Item number 102.
Yes.
Hello, retired on 31st March 2021.
Interest on?
Interest on, my lord, PF gratuity and leave salary. Enter.
Retirement 31st March na May.
My lord, 31st May, my lord, retirement.
31st May.
31st May 2021. PF gratuity and leave salary.
Yes, ma'am.
একই রকম হবে, ওই দুটো প্যারাগ্রাফ অ্যাডিশনাল যেটা করে দিয়েছি ওটা ডিসপোজড অফ।
Item number 103.
And for the state loan.
Retired on
31st January 2019. Interest on PF gratuity and leave salary.
স্টেট রেসপন্ডেন্স, না স্টেট রেসপন্ড, হ্যাঁ ফান্ডের ব্যাপারটাও হবে, আর প্যারাগ্রাফ 4টা চেঞ্জ হবে। ওই প্যারাগ্রাফ দুটো অ্যাড হবে, ডিসপোজড অফ।
Item number 104.
Yes, retired on
September 30, 2018. Interest on my lord, PF, gratuity and leave salary.
thirtieth September 2018.
My lord.
It is not represented. Disposed of.
Item number 105.
Yes,
Retired
retired
on my
on
lord, December 31, 2018. 31st December 2018. Interest on my lord, PF, gratuity and leave salary.
December 2018.
My lord.
Disposed of.
Item number 106.
31st March, my lord, 2018. Retired.
Interest on
My lord, PF, gratuity and leave salary.
gratuity and
Leave salary, my lord.
31st March 2018. এই রণজিৎ তুমি থেকে যাও, কারণ ওই প্যারাগ্রাফ দুটো ওকে আবার আর একটা দুটো আছে করে নিতে। Please post down. ওই প্যারাগ্রাফ দুটো কিন্তু ইনক্লুড করবে প্রত্যেকটাতে। একটা এফিডেভিট দিয়ে দাও না।
Item number 107.
Well, I am for the petition in this matter. The petitioner before your lordship was an employee under the Bongio Gramin Vikas Bank. But he retired from service on 30th of April 2013. But at that time, there was no pension scheme. But there was a provision for refund of the CPF. I received CPF. But that amount of CPF, once I return, then I should be considered for pension. I moved the High Court. Page 65, the order was passed by Justice Montha. The time cannot be extended. You cannot get the benefit because you have not refunded the amount. That was an order of 2021. Page 65. May I place it for your lordship?
Yes.
The issue as to whether the pension will be given or not went up to Supreme Court. On 12th of August, page 27 of your lordship's petition, Supreme Court directed the pension scheme is to be introduced. Accordingly, my lord, page 37, the bank had, my lord, introduced the pension scheme. There is no dispute to that. I have been given the pension, my lord, from October 2024 after refund of the entire amount what I received under CPF with interest.
Page 37.
Page 37 is 27 is the order of the Supreme Court, and page 37 is the scheme.
Just a minute. Yes.
Well, I have been
From
given
1st
the
of November 1993.
and I have been given pension from November 2024.
Date of your appointment. Date of your retirement.
Retirement in 2013. Area payment has not been given. That's why before your lordship from May 2013.
So you have been given pension from which date?
November 2024. Well, there was a calculation of my outstanding at page 41. In 2019 itself, the bank said that you have to amount to be refunded 4,84,761.
No, but the with regard to payment of ADR, prayer was made before the Supreme Court for longer time, as it is recorded in page 20, page 30. Come to page 30 of the relevant part of the order of the Supreme Court.
Yes, my lord. Implement the two. One.
Just a minute.
Implement the pension scheme in respect of the employees of regional rural banks with effect from 8/1/11/93 in terms of the memorandum of settlement date 28/10/1993 applicable to NCB and to pay consequential arrears of pension, family pension.
Next paragraph. Before we consider the prayer for grant of longer time.
Implement the grant of computer increment.
No. After that quotation, quoted portion.
Before we consider.
Yes, read it.
Before we consider the prayer for grant of longer time, we expect the respondent to pay at least a reasonable amount towards the arrear of second week of October 2024. Arrear by second week of October 2024.
Yes.
Arrear. Obviously, everybody must be paid at least current pension. Depending upon the compliance made by the respondents, we will consider the request of grant of longer time to make compliance. That is the authorities' choice to go to the court paying for longer time. But area to be paid.
Therefore, Supreme Court has directed that that we expect the respondents to pay at least a reasonable amount towards arrears by second week of October 2024.
Yes.
Obviously, everybody must be paid at least current pension. So that has been paid from.
No. Nothing has been paid, but in terms of the order of Supreme Court, even also has nothing paid from so far as the area is concerned.
Pension, they have already received the pension from October.
The pension I have received. I have not.
Yes. No, Mr. Bhattacharya is submitting that he is receiving pension from November 2024. He is praying for area.
No, well, he is not entitled to get.
Why?
Well, kindly look at the dates first. In 2028, my lord, the pension scheme came. 2018, 1st April, the pension scheme came in the bank. Before that, there is no pension scheme. Petitioner retired on 2013. He is not applied for the pension. He unable to deposit the refund. He came before the Honorable High Court. Honorable High Court dismissed his application. In 2024, in 2018, application is not annexed with the petition. In 2024, amendment took place. Page 37. In amendment took place in 2024. After this amendment came, my lord, he applied for the pension as a second optee. He is not applied for the first occasion in 2018. He applied in 2024. And my lord,
but it is recorded in the order of the Supreme Court dated August 24.
The regulation,
1st of November 1993.
Well, now page 39. Page 39 of his application, the regulation. What? 6.3. Notwithstanding in merit.
Just a minute, page 39.
39, my lord.
39 of what? Pension regulation.
Pension regulation. Amended pension regulation.
Yes.
Which is point number 6 in regulation 50 of the said regulation. The following regulation shall be substitute, namely. Now, my lord, subclause 3. Notwithstanding anything contained in this regulation, in case of an employee or as the case may be, family of the deceased employee who was eligible to opt for pension
or as the case may be, family pension under the said regulation, but did not opt or opted, but did not refund the money, but refunds or authorize adjustment of money under the clause A and subclause 1 of the regulation 3, or as the case may be under the subregulation 2, subregulation 3 on or after notification of Bongio Gramin Vikas Bank Employees Pension Amendment Regulation 2024 shall be entitled for pension, family pension, or as the case may be from the date of refund or adjustment under the clause C of the subregulation 1 of regulation 3, or as the case may be subregulation 2 of the regulation 3, or the date of retirement or resignation or death, as the case may be, whichever later.
In case of pension, petitioner, which date was reckoned in the matter of releasing pension?
From he refunded in October 2024.
But the previous effort of the petitioner to refund was negated by this court.
He is not refunded refunded. It's not a single money. In 2018. That's why he came before the Honorable High Court that I am praying for time for extension.
No.
That was denied by the Honorable High Court. In 2024, second time he applied for the my lord pension.
Page 56, no outstanding. Page 56. They have given it.
My lord, date, kindly look in the date, 56, in 2024 September.
That is exactly what I say.
He is applied
the scheme came, my lord, I am entitled to.
Yes, after 24, but in 24 scheme, my lord, there is no scope for area pension. Specifically, the regulation says so.
Means this has been in terms of the order of Supreme Court, the notification has come.
But notification itself says, my lord.
You cannot avoid the.
I cannot avoid the notification also.
You cannot avoid the order of the Supreme Court. Page 56, no due.
Date, my lord.
Yes, I admit that. I admit that. It is not a dispute that I am not admitting. It is a fact.
And he is applied in 2024 scheme.
The refund was refund of benefits under contributory provident fund scheme.
Yes.
2024 scheme.
Only PF, the employer's contribution. 4,64,000 I refund.
Yes, my lord. But in 2024 scheme, not 18.
In case of pension which has been allowed to the petitioner, that is in terms of Bongio Gramin Vikas Bank Employees Pension Amendment Regulations 2024.
2024, my lord.
Now come to page 39. In case of the petitioner, page 34, it is provided under subclause 3 that Bongio Gramin Vikas Bank Employees Pension Amendment Regulations 2024, which is in bold letters, shall be entitled to pension, family pension, or as the case may be from the date of refund or adjustment under clause C of subregulation 1 of regulation 3, or as the case may be subregulation 2 of regulation 3, or the date of retirement or resignation or date as the case may be, whichever is latter. Now, in case of the petitioner,
he applied,
which date was considered for payment of pension?
He refunded. He refunded, date of refund. He refunded on the September 2024.
Then pension from October 2024.
October. It took time. He received pension from the 1st November 2024.
Where you will exchange your affidavits.
Smart.
এসো 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 শুভেন্দু matter is heard in presence of the learned advocates representing the petitioner and bank Bongyo Gramin Vikas.
No, my lord, now it is West Bengal Gramin Bank.
West Bengal, now West Bengal Gramin. West Bengal Gramin Vikas Bank.
Not Gramin Vikas, man. Only
Vikas.
Only West Bengal.
West Bengal Gramin Bank. West Bengal Gramin Bank. Authorities. Stop. Mr. Next paragraph. Mr. Kamalesh Bhattacharya, learned advocate representing the petitioner, submits that petitioner was an employee of
Bongyo Gramin Vikas.
Bongyo Gramin. It has renamed subsequently.
No, my lord, is merger took place.
Bongyo Gramin Vikas Bank Limited, who retired on superannuation on 30th April 2018.
2013.
2013, my lord.
30th April 2013.
2013. 2013. Retirement age.
Tell me the date of retirement. 30th April
30th April 2013.
30th April 2013. Stop. Petitioner was not paid pension as prayer of the petitioner to refund the benefits which were allowed to the petitioner in terms of contributory provident fund scheme was not allowed by an order dated 23rd February 2021 passed by a coordinate bench on a writ petition being WPA 3563 of 2020. Stop. It is submitted on behalf of the petitioner that pursuant to the order passed by the Honorable Supreme Court on 12th August 2024, in petition C number 1798/2018, in SLP C number 39288/2012, C Raja Reddy, President, retirees of Regional Rural Bank, page 27 versus Rajiv Kumar. Pension was sanctioned in favor of the petitioner in terms of Bongyo Gramin Vikas Bank within bracket employees plural apostrophe close bracket pension regulations, 2018. Stop. 2018 from October 2024.
Yes.
From October 2024, petitioner prays for release of arrear pension from the date following the date of his retirement till September 2024. Next paragraph. Mr. Boidurjo Ghoshal, learned advocate representing bank authority, has opposed the.
It was commenced from November 24. I have paid for area from May 13 to October 24.
That's just
It was commenced, pensions commenced from my representation at page 67, my lord. You have specifically stated this. Area I want from May 2013 to October 2024. That calculation also have been made by me.
pension commenced from 1st November.
Where from you are getting this?
I give my lord.
This one?
Yes, yes.
Where is the date written?
Last, my lord, 27, point number 27. Right side.
Date of commencement of pension 1st of November 2024.
Yes, that is exactly what I am saying.
Yes.
So I prayed
So
for.
you are seeking arrear from the date following the date of your retirement till 1st of till October 2024.
The same.
Yes.
Till October 2024.
From May 2013.
Yes, yes.
Arrear. My retirement is May 2013.
Same thing from the date following the date of retirement, sir. May 2013. আচ্ছা কি বলছিলেন মিস্টার বৈদ্যুতিক ঘোষ learned advocate represented petitioner representing the bank authority has opposed this writ petition on the strength of on placing reliance on page 39 man. Yes, on placing reliance on regulation 6 within bracket 3 of Bongio Gramin Bikash Bank within bracket employees plural apostrophe close bracket pension within bracket amendment close bracket regulations 2024. Stop. It is submitted that in terms of regulation 6 within bracket 3 pension was allowed to the petitioner from October 2024 after a refund of benefits which were paid to the petitioner under contributory provident fund scheme. Stop. According to the respondent bank, petitioner is not entitled to receive ADR pension in view of the provisions as contained in regulation 6 within bracket 3. Aforesaid regulation 6 within bracket 3. Stop. Next paragraph. Issue needs to be decided on exchange of affidavits. Let affidavit in opposition to this writ petition be filed by 3 weeks from date. Stop. Affidavit in reply thereto, if any, be filed by 1 week thereafter. Stop.
Give me 2 weeks.
2 weeks thereafter.
Very sick
stop.
man.
Petitioner shall be at then 4 weeks, 2 weeks. 4 weeks, 2 weeks. Stop. Petitioner shall be at liberty to mention the matter before the appropriate bench for hearing after the time fixed herein above for exchanging affidavits.
Deeply obliged. Obliged to lordship.
When you are when the matters are called on, why you are not appearing, Mr. Joshojit Mukherjee? In the morning there are 2 matters you did not appear. I had to adjourn the matter.
I could not reach the court today. In the morning, I just came in the second.
Matters will come up probably tomorrow.
But I'll be there.